still here, but I don't want my stretching on camera.
Well, good morning, everybody. Thanks for joining a little early. I got most of your screen names in check here. There may be one or two I haven't gotten to yet. One particularly is Kevin Long. I'm not sure who you're affiliated with. I couldn't find you on any of my lists.
Your Honor, this is Joe Wilson. He's a Quarles lawyer. I think that's a remnant from the last hearing on this camera. So you can change that to Quarles 2.
Okay, so it looks like we have three. I'm calling them WEPCO cameras, but I don't know who is planning to use them. So I'll just put a number on there. We'll just adjust the names when I get to that. And if you haven't seen yet, the live stream's already going. Figured people might want to join in earlier, make sure that's working. Like we're just waiting for Cub and Sierra Club. Oh no, we have Cub. We have Cub Witness, but oh yeah, Steve's in. Oh, just missing Corey. Oh, there's Corey.
So, Your Honor, the way you have them labeled right now, we'll be using video from 1 and 3, but we'll never use 2.
Okay. Thanks. Yeah, I'll just try to, from the screen, I'll adjust the names if I get a chance to do that, but thanks.
Sounds good. Thank you, Your Honor.
Milwaukee. Everybody we're expecting. So we have all attorneys present for the parties. Seems to be, we're not missing anyone who's represented. And it looks like all the other parties without representation are present. We just might be missing a witness or two. So I think we can get the show on the road here. Thanks everyone for joining a little early to give us a chance to adjust those names quicker, get started a little sooner. Right, so we're good to go. Let's get on the record. This is docket 6630 CE 317, the application of Wisconsin Electric Power Company for a CPCN to build 5 gas-fired single-cycle combustion turbines, generating up to 1,100 megawatts. We're calling this the OCCT project for short. You'll probably see that acronym around. My name is Michael Newmark, Administrative Law Judge for the PSC, and we are on Zoom with the parties and commission staff in attendance. We have had members of the public are free to join us using our live stream. Not really join, but observe. We're also going to be taking public comments on Tuesday, March 25th, 1 p.m. and 6 p.m. at the Oak Creek Community Center Ballroom in Oak Creek, Wisconsin. And that's going to be a joint hearing with both this docket and also 66 CG 140. So we're on, and in addition, we're taking written comments. They are due no later than March 27th through the commission's website or by mailing those comments to us on the address listed on our notice of hearing. So that's how you would participate for the public, but now we're taking evidence from parties and commission staff here today. So first order of business is just checking everybody in by taking appearances on the record. So I got the service list here. I sent this out to parties yesterday. Like I mentioned many times, this is the information we'll use to serve parties, including commission's official documents. For example, the final decision in the case will be emailed to this list. So please make sure we have identified the people you need to receive that document. And if there are any changes, you can note them here. I may ask you to file something as well, depending on how much of a change we need to make. But let's start off with Advanced Energy United. Who's representing them?
Good morning, Judge Newmark. This is Nikhil Bijaker with the law firm Keys and Fox representing Advanced Energy United. I can just mention as well that my colleague, attorney Travis Murray, is on as well, but I'll be lead counsel.
All right, thanks. Citizens Utility Board.
Good morning, Corey Singletary on behalf of the Citizens Utility Board, and I also have with me today Dr. Steve Keim representing CUB.
City of Milwaukee.
Your Honor, this is Assistant City Attorney Tom Miller on behalf of the City of Milwaukee.
Okay, Clean Wisconsin.
Morning, Your Honor. Brett Cordy on behalf of Clean Wisconsin. I'm also joined by Katie Nicola.
So Healthy Climate Wisconsin.
Good morning, Your Honor. On behalf of Healthy Climate Wisconsin and Union of Concerned Scientists, Grant Snyder of the law firm of Keys and Fox LLP, and it's just me today.
All right. Public Service Commission. You're muted, Stephanie. Nope, still not hearing you. I can unmute you though, if I can find you on the list.
You hear me?
Oh yes, there we go. Thanks.
Okay. Good morning, Your Honor. Stephanie Bedford, Assistant General Counsel, appearing on behalf of the Public Service Commission of Wisconsin.
All right, thanks. Renew Wisconsin.
Good morning, Your Honor. Sharif Halawish for Renew, Wisconsin.
Okay, Sierra Club.
Good morning, Megan Moxpress on behalf of Sierra Club.
All right, sticking with the list, Union of Concerned Scientists.
Good morning, Your Honor. Again, Grant Snyder of the law firm of Keys and Fox LLP, also representing Union of Concerned Scientists.
Thanks. Walnut Way Conservation Corp.
Good morning, Your Honor. Eduardo Castro appearing on behalf of Walnut Way.
so let's go off the record. So I'm not seeing you on this version of the list, but you've been getting the emails, correct?
Yeah, I am on the email chains.
Okay, I think you're probably on the list. I'll just make sure that I'll change. This document really doesn't reflect what's in the database, but I'll double check that. All right, so let's get back on the record. Wisconsin Electric Power Company.
Good morning, Your Honor. Attorney Patrick Proctor Brown on behalf of Wisconsin Electric. I'm joined by attorneys Wilson, Phillips, Rosso, Gutner, and Fortune, and Attorney Goldschmidt will be here later this afternoon.
So seeing everyone here is Rosso. I don't think I'm seeing.
So we've had some celebrations here since we filed the notices of appearance. So Attorney Zank is now Attorney Rosso, and Attorney O'Connell is now Attorney Gutner. Sorry about that.
O'Connell. Okay, I think that's the change we'll need. So I have Rosso.
So yeah, you have Rosso, and then O'Connell would be Mackenzie Gutner now.
And is the email going to change for O'Connell?
Yes, I think it's just swapping the two names out.
All right. So if you could just file an updated notice of appearance just for O'Connell, then we'll have that on record. So I'm not typing it in on my own. Probably don't want that.
Sounds good. Thank you, Your Honor.
All right. Okay, and so Wisconsin Industrial Energy Group.
Yes, good morning. Steve Heinzen for the Wisconsin Industrial Energy Group.
And Wisconsin Local Government Climate Coalition.
Good morning, Your Honor. Matt Frank from Murphy Desmond representing the Wisconsin Local Government Climate Coalition.
Great. Well, welcome everybody. Thanks for joining us. That's everybody we're expecting. And you can start taking some of our off the record items here. So let's.
Are you saying that, or do you want to go off the record?
I'm just going to say that now. Yes, let's get off the record. Giving you a preview, so you slow down on the fingers. So I guess first of all, I think we may want to just discuss if we can excuse any witnesses that aren't being asked any cross questions. I know we had cross some witnesses have been identified for cross, so I'll skip those unless something's changed. So let's just begin with the applicant witnesses. We have cross for Arndt, Gerlikowski, Hagerty, Hall, and is it Correr? There doesn't appear to be cross for them. Just chime in if any. Oh, I see Attorney Vijayakar. Hang on, Attorney Vijayakar, you have your hand up.
I think Ms. Bedford might have been before me, but I'll go anyways. Your Honor, it's only to add that the only change to our cross-examination list is that we've narrowed cross and we no longer have cross-examination for witness Gerlikowski. I understand he is still listed as crossing that witness.
Okay.
But that's our only change from yesterday to today.
Okay. All right, and Attorney Bedford, you had a comment?
Yes, thank you. The commission does have a short cross-examination for applicant witness Arendt.
Okay, yeah, there's questions for Arendt, but I was asking, okay.
I just wanted to make sure because we didn't have it in our previous
and there's nothing, that's fine. As long as just trying to see if there's anyone we can excuse that have no questions. So my question to the group was, are there any questions for Hall or Correr?
Judge Newmark, in HCW and UCS's pre-hearing notifications yesterday, they reserved cross for both Hall and Correr.
Oh, okay.
After reviewing the record yesterday, we no longer have questions for Correr, but have short questions for Hall.
Okay, sorry, we missed that. So that's okay. So did anyone else have questions for Carrere? Doesn't look like it, right? Okay, I just wanted to read. Yes.
Yeah, just a quick thing on pronunciation. I believe it's Arndt and Corer.
Corer. Okay, thanks.
Yep.
Got it. I don't know if I'll remember that, but thanks for letting me know. Is there any questions on the comment for Corer's rebuttal? That was just kind of a simple change, nothing. Oh, and then there's the rebuttals. Just some simple type changes for that. So, okay. So I think it's fine. We can, so it's just Corer we can excuse. Is that everyone good with that? And we'll go on the record later and I'll just list up the people who we are excusing. Looks like there's no questions for Nicholas at the moment. Is that correct? Scholl, any questions?
And before you get too far, I think you grabbed Lambert in the highlighting.
Thanks. And I guess I should probably say right away, it's fine if people just interrupt with objections, or if you want to chime in with something, raising your hand. I'm not necessarily watching that, so I may just skip it all together. Skip it all together if I don't see it. So feel free just to chime in. That's, we're at a hearing. You'd basically just be chiming in a polite way. So that's what we do here. Sieber, any questions? Try to be more diligent on my highlighting. Stasek, it doesn't appear to be any questions. I did have a question for Stasek in 316 that we probably need to get in the record here as well. Fortunately, that's in confidential, but so I don't think we can, excuse him at the moment because of that. And it's just so that the records are reflect the same information. So Taruli, questions for that witness, just changing typos. Zasner word. Someone's coming in here. Gesture was with who? The clean? Yeah.
Yes, Your Honor, Douglas Chester is our witness.
Coming in now. All right. Anything for Zeisner word? Shall we ask one more time? And the basic corrections. Zamuto. Letting more people in. So there was a few corrections for that testimony. Are there any questions about that? Citations, so nothing too major there. Okay.
Your Honor, just I know you're asking about some of the changes. We only have questions on two small points, one for Mr. Arndt and one for Mr. Haggerty when we get there.
Okay. Let's continue on with the witnesses here. Just make sure we stay on track. So these two we're going to excuse. How about Makun? There's a lot. There's cross for, is it McQueen?
Applicant has.
It's Macune. Nice to meet you.
Okay. And yes, I thought you had questions. I don't think I added your questions in. I got that email later. So, all right. So we'll keep you in there. Burgess,
Applicant has cross, Your Honor.
Yeah. And Keim,
Applicant may have cross for Mr. Keim, Your Honor.
Singletary.
Applicant will have cross for Mr. Singletary.
I don't know why I missed that email. Okay. Goggin.
Applicant would have cross, Your Honor.
Guess it's good just to review. Holting.
Applicant would have cross, Your Honor.
Jester.
Applicant would have cross, Your Honor.
Sherwood.
No cross for applicant of Sherwood.
Okay. So did anyone else have questions for Sherwood at this point? Okay. Seeing anyone, so we can.
I'd like to take witness Sherwood on the stand, Your Honor.
Okay, not a problem.
And I had a question about your notes, if you're taking those at this time.
Let's do the list first, and then we'll go back to the notes. Healthy Climate Wisconsin and Union of Concerned Scientists, so that's Nunez.
Applicant has cross, Your Honor.
Yes, that's Kel. Nobody. Okay, we can excuse Kel. Pilo. Nobody. Okay. So before I excuse Pilo, there were a number of corrections we'll need to review here, or at least I've provided. Is there any issues with these? Do you need some clarification?
No, I thought that your notes were pretty complete in that sense.
Okay. And then Pilo 4 makes sense. You're good with that one?
Yes, yes, Your Honor.
Okay. All right. How about local government? Carlson, any questions for Carlson?
Applicant has questions for witness Carlson.
Oh, and then staff, right? Grant, I think. No one for Grant? Okay, and I think they may just appear anyway, right? So, well, let's just go through any questions for Munson, Rademacher, Rowe, Tomasewski? Nobody. Okay. All right. Yeah. So let's go back up and deal with comments. So we're starting with Arndt. Is that right?
That's right, Your Honor. We just had a question about the footnotes in the block quote on rebuttal. So that same block quote with those same footnotes appears in his Paris Rice testimony. We think it kind of adds value to the commission by explaining what those two terms are. And to be honest, not really sure how we would load that into brackets in a block quote.
Yeah, it was oh, okay. So it would just be putting the actual word into the bracket instead of PRM, putting planning reserve margin in brackets. Instead of variable energy resources, put that in brackets.
So, Your Honor, the footnotes actually explain what that term means, however briefly. So that's why we did it.
Right,
It's the same as in Paris Rice. So we can put the brackets in the block quote, but we'd like to continue to include the additional information about what those words mean for the commission.
Yeah, it's interesting because I wouldn't think that you could add a footnote to a block quote like that, but because it's not what the document doesn't have that footnote in it, right? So that's kind of
I think that's pretty standard for style, right? So you'll explain what a word means that's explained elsewhere in the documents for the benefit of the reader. Not aware of any rule against it for sure. Blue Book doesn't address it, for instance. Chicago Manual of Style doesn't address it. It's already accepted into the record in Paris Rice. So
yeah, I'm not going to catch everything, that's for sure. But when I do see something, I'm gonna point it out. Yeah.
And I guess I would say that there's no question that that information is accurate, right? It's referenced elsewhere in the document as those things. Variable energy
understand your
resources.
point. I understand your point. I guess I'm going to stick with the instructions. What I'd like to see when it comes to quoting documents is that it just looks exactly like what's in the document, except you could add emphasis, but then you want to note that. But to put a footnote inside of a block quote, to me, it looks like that's what's in the block quote. That's what's in the source document. So yeah, it's a matter of style, but I'm gonna order you change that.
So, Your Honor, like I said, we would like to include the information in those footnotes. So I would suggest we can include the brackets and then drop a footnote that explains them at the end of the block quote.
You can put it in the bracket, within the bracket.
Okay.
Okay, because what's in the bracket's not in the document, not in the source document. So I think that's how I would read that. So that'll work.
Okay, Your Honor. Thank you.
Mm-hmm.
The other one we wanted to bring
up, or
up
if you just
is,
want to put the footnote in the bracket, that would work.
Okay, we'll go with that last option. We'll put the footnotes in brackets. Thank you, Your Honor.
Yeah.
Yeah. The other one we want to bring up is the new Haggerty exhibit. So to my knowledge, that order is not out. Evidence is closed in this record.
It's not closed until I close it. So
sure.
Yeah.
Well, no, the parties can't submit any evidence, Your Honor, without
that's not
leave,
okay.
Right?
Go ahead. Let me have you speak. That's fine.
To my understanding, this refers back to a couple of paragraphs of Mr. Haggerty's direct testimony where he includes an exhibit from Excel's submitted IRP for the point that other utilities are including natural gas resources.
We have the background. We don't need to. So what this asks is that, well, what I'm going to do is if that order that relates to the Minnesota PSC decision on the IRP is issued, I'm going to put it in the record. And at the moment it gets accepted on IRF, parties will have 3 days to respond to it. So you treat it as a request for additional evidence, which triggers motion practice under Section C of the FMO. So it's like if the commission wanted to add another document to the record, you get the same opportunity. And basically it will just be the official order from Minnesota Commission based on the decision it made on February 20th. So
I think we're fine with that. We're just, to us, right? Like, where does it end for adding additional orders from other states in pending matters? If we get to a hearing, the order doesn't exist, no party has sought to put it in. When does the evidentiary record close on these sorts of things?
Well, there's always an opportunity to add evidence.
For the parties, right, Your Honor?
By using the request to offer additional evidence. That's the process. I mean, we've done that many times. It's nothing new.
I would say typically on the motion of a party.
Well,
right? But thank you, Your Honor. Appreciate it.
That doesn't matter. I'm running this case, and this is my record. So you'll have an opportunity to respond. Okay, so there's Danielle Sikochi. Is that someone we recognize? Someone's in the waiting room. CYCHOSZ.
She's an employee of Wisconsin Electric, Your Honor. She'll just be observing.
Okay.
And she can go. We can tell her to go to the YouTube.
Please do. Yeah, that'd be great.
Thank you.
Okay, so any other questions from WEPCO on the comments? Okay, so we'll move on. More comments. AEU, any comments, questions?
Judge Newmark, just one question. It's sort of a global question too, I think. A couple different comments about creating a new exhibit related to sort of showing the results of variables. I spoke with our witness, and we think we understand that essentially you want an exhibit that shows what we're describing in that footnote. Do I have that right? I mean, I think in some of the reason that we were a little confused was that some of the footnotes don't really talk about the results of a variable per se, but just any additional clarity would help as we pull together those exhibits.
Yeah. So it's another just general topic. I kind of raised it at the end of the list. I think it relates to this, but it's more of this a discussion. When I was going through the testimony, this kind of got raised as I'm not sure what to do exactly when it comes to this. I think we're now accepting testimony with links as long as they're disclaimed that the links aren't part of the record. But then when you go into the link, it's just you can't really verify what's being presented, and that just raises issues with veracity. So when it comes to like, well, the PILO exhibits, these links just don't work. I think they're just not formatted correctly, because it's using a Google search and then it gets to the MISO hyperlink. So it's just broken. So that's just I think more of a thing that has to be fixed. For example, this link, it doesn't bring you the information that's being cited. It's just sort of a, the entry page into a set of different reports and data. It doesn't bring you to the actual report or source of the data that you're using. So I think that's sort of the problem with these links. And when it comes to like the AEU documents, the wind exchange map, I can't find where it shows the speed at 100 meters above sea level. So it's just a map, and it shows a lot of different speeds and a lot of different sea levels. I don't know if it was the average or something, but it's not clear to me where that data is coming from. So, and then but for example, another example is you can definitely pick out this number from this link. It's very clear where that exists. So to the extent that you can make things more clear as to the link related to the data, I mean, that's, no one's objecting to this, but it's just a note I want to make people think about, because just throwing a link on it doesn't work. It just raises questions rather than it's meant to answer questions and meant to provide information to the parties. But this is not, these things just don't go anywhere. So it's just a broken part of the process. So I was on the fence with this. I don't really know. I think when it comes to the AEU testimony, it's the problem is I think and I think other parties had corrected this in the one the 316 case, where they were able to take a screenshot of the inputs and the report that it creates. Like if it's a graph or something, it can show you the result, and then that could go in the testimony or an exhibit, so that we can see where the data is that it's coming from, and it's been validated from the source. But no one is questioning this information. I don't think it's necessary to have you remake things at this point, but I think you want to keep that in mind when you're doing this kind of work. And I guess there's also the issue with this testimony. It's also the appendices, which I've not really seen before with other parties. So I'm not sure if that's an attempt to solve that problem, or
not a specific attempt to solve any problem, just wanted to make some of the supporting data available without clogging the testimony. But on your point about your explanation helped, Your Honor, about what you're looking for, and I think we can pull together exhibits that show more directly the proposition that was in those footnotes that maybe is not as readily obvious when you access the link. So I think we have what we need.
Okay.
To go ahead and make those exhibits.
I think I actually misnumbered this. There's already a 3. So you'd want to move that, advance all those numbers instead of repeating 3. Yeah, sorry about that. I didn't see that. All right. Well, yeah, like I guess do your best. I don't know exactly where this is going because it's just not quite something I've seen before. So I'm willing to just have you try attempt to do something here so we can just keep the record straight and make sure that we're not, it's not a misleading, I guess, is the most important thing, so that we have information that's validated. Again, if it's currently those links are not record evidence, so it's not that the record is wrong at this point. It's just that just because parties couldn't validate it based on the testimony. I think it's fair to have some other presentation of that given to everybody at this point.
Understood, Your Honor. Thank you.
Yeah, thanks. Okay, so we'll move on with Citizens Utility Board.
Excuse me for a sec here, Your Honor. Cub doesn't really have any questions on your comments. They seem to be pretty clear, and I think we've run down the ones where you would like us to replace the exhibits we offered with references to exhibits from the company. And I think there's one where there's a request to either cite or offer an exhibit, and I think we'll go ahead and or disclaim. I think we'll go ahead and add a disclaimer there. The one question we did have, just sort of administratively, you had a similar request for EX Cub Singletary 1 for us to replace that with the executed copy. I just want to make certain we're all on the same page that I think I just checked this morning that there's no revised version of the underlying data request response in this proceeding, which I think was CW 204. And so would the company be providing that so we could refile that?
Oh, any answers from WEPCO on that?
To be honest, I don't know what Mr. Singletary is talking about, Your Honor.
It's the engineering, procurement, and construction agreement with Burns and McDonnell. There was a copy provided in a data request response, CW 204, that I believe what the judge's issue is I don't think it has signatures at the bottom, at the end of it. I think that's what he's looking for.
I'm told we can provide that. So I think we'll probably just provide it to you in email for you to make the exhibit.
Okay. That's
or
great.
We'll revise the data request response. One of those two.
Okay. If you could just let me know after the hearing which way you're going to proceed, so I know which place to look.
Will do. Thank you.
Thank you.
All right. Yeah, I did have a note here as well. Is that all you had, Agent Singletary?
Yes.
Okay. I did have a note here on Burgess to include press articles that you cited as an exhibit, and actually I didn't have a placeholder for that in the Burgess exhibits. I was actually thinking about removing that request. I think if you haven't filed them yet, I was going to just let it go and have those just be in the record NRE. I don't know if I didn't take the time to kind of sort out which ones and what they were, and so I think we'll just leave the record the way it is.
We'll certainly defer to what you prefer. If you would like us to add, I think it would be 39 at this point. And the cleanest in my mind, in terms of not having a whole bunch of new documents and making the citations easier, we could kind of roll them together in one document and cite them to one exhibit, or we can leave them as you suggested with just the NREs, whichever you would prefer.
All right. Well, let's, why don't we have you propose that filing, and there'll be an opportunity to respond. You don't have to go through the whole motion practice. Just when it's filed, we'll do the same thing with that order. Just file it, and then parties will have a chance to respond to it. I think this case is so publicized that to have these articles in the record is useful. Commissioners are going to be looking. I'm sure they've heard about this from the press, and it's good to have this stuff on the record. But since I don't really have anything identified, it would just be the articles you've already cited to.
Understood.
And then like I said, that'll trigger a response period for everyone else to review, make sure you got that right.
Okay. Thank you, Your Honor.
So that's all for Cub.
I believe so, Your Honor.
Clean Wisconsin, any questions?
Yes, Your Honor. For Sherwood Exhibit 4, it contains the first 2 pages are calculations completed by the witness, and the remainder of the document is EIA data. I could add a cover page to each of those sections explaining what they are.
That'd be great. Thanks.
Okay, thank you.
That's it for Clean. How about HCW UCS?
Judge Newmark, 2 comments. So first, actually, it looks like it might be in there now, but an offered evidence list that I saw yesterday that you distributed for Healthy Climate Wisconsin, the SIR was not in, but it looks like you have it now.
Yes.
Okay. And then the second question related to possibly providing Clean Wisconsin's environmental assessment scoping comments as an exhibit. My understanding of the commission's past practice is that the way that we would do this is to offer it as the exhibit sequentially to the last exhibit that we have. So this would be exhibit HCW UCS Nunez 8, and then we would edit the testimony if we were going to offer it as an exhibit to reflect that new submission. Is that correct?
Yes, that's right. Sorry, I forgot to put that in my instructions. Yeah, exactly. Yeah, and just so you all know that the EA comments don't go on the record unless they're offered by a party or commission staff, but it's not, those are used by staff, not by the commission. So unless you put it in as an exhibit, it's not going to be read by the commissioners.
Understood. No further questions.
Okay, great. Oh, and I did want to mention with the SIR rebuttal. So there was a trick to the SIR rebuttal, so that, and it really does apply to all the parties that have filed. The way we should be handling SIR is that it just gets emailed to the service list and to me before the hearing, and then we file it after the hearing. So the important thing though is, and the reason for that is I didn't want to have you rushing to file everything right before the hearing. So, and also it's not really a required filing. It's not, this is not on the schedule. This is kind of extra schedule filings. It's just documents you're using at the hearing. And in this case, you're going to offer it as testimony instead of speaking at the hearing, but it's not a required filing until it's received here, and then you should be filing it later. So that's why I didn't notice that there was SIR from Nunez because I wasn't looking on IRF. So just in the future, if when you're back here next time, just need to email those documents for before the hearing. There also may be more corrections. So there are some corrections, I think, with the WEPCO filings. We'll have to review that too. But in this way, you're not having to refile. I can just tell you now what the corrections are. So that's why in particular I didn't see this SIR come in. How about WEG? Any questions? Yeah, there are a lot of different citations. I asked you that, right?
Yeah, you did, but Your Honor, I do have a question that I would like to ask of you.
Sure.
And there are 2 places in the testimony that you have asked I guess directed be stricken from the record, from the testimony. And I'd like to just address, I understand why you are asking for that to be stricken, but I think in the first instance, which is on page 16, that the amount that should be stricken should be considerably less than what you have asked. And my suggestion, or I guess my request would be to you is if you would agree that really it's lines, the sentence that begins on line 6 and ends on line 9 together with the footnote. But I think that the remainder of it is consistent with what is asked of the question.
Okay, so this is 16. Yeah, I think that's correct. You're right. So yeah, let's adjust. So line 6 to line 9. Okay. That one might have gotten in there somehow.
Okay. And then and the footnote as well, of course, then.
That'll be included, yeah.
Yep. Okay.
Okay, yeah, thanks for pointing that out. And
No, thank you.
okay, so for Carlson, any question? Oh, there are no. Oh, wow. There are no corrections. All right, good job. How about commission staff?
Your Honor, we do have a question about your comment on Dr. Grant's direct testimony. The source of the data that you were referencing in your note is the MISO Generation Interconnection Queue website. The data was downloaded in December of 2024. And so if we add the HTTP web address without a hyperlink, would that resolve your concern with this testimony?
Yeah, so the NRE disclaimer you'd want to have on there, and then whether it actually links or not is up to you. Haven't been requiring we try to clean the document from links, because that seems to be almost impossible to do nowadays with the way these documents are being processed by computers. So a lot of times the links just reappear automatically. So you can leave the link, but put in the disclaimer.
Certainly, thank you.
Right, anything else for comments? So let's get on the record.
Can I ask one
Yeah,
thing?
oh yeah, go ahead.
Can I have Miss Waxpress, can you lower your camera because I can't see your mouth when you talk? I know you haven't talked much yet, but it's your word, your name is hiding it. That's great.
Is that better? Thank you.
That's better. Thank you.
You
I
weren't
know it's a
expecting that,
minor
were
point,
you?
but
All right, let's get on the record. So we've discussed witnesses we can excuse, and I hope I've highlighted them all. Korer, Nicholas, and Scholl, and Sieber, Teruli, Zasner, Word, and Zamuto. Let's go. I think that's yeah, well, Sherwood is excused technically, but I think they'll be calling them anyway. Kell is excused. Pilo is excused. And the commission staff will appear, though there's no cross for them. All right, and then in terms of corrections, we will have, we'll need to mark Burgess. Yeah, okay. Exhibit Cub Burgess 39, which are copies of the articles, the press articles cited by the witness in the testimony. The filing of that document will trigger 3-day process to respond, what we call the request to offer additional evidence, motion practice. Just consider the filing the motion, and then the rest of the process follows. If that's anything we else, all we had for additions. Oh, okay, so yes, so we can go ahead with that. And I did want to just go off the record for one more thing. The Sursa rebuttal, there is just a few corrections. So it's just the Gerlikowski and Stasek. We just want to change Mr. Grant to Dr. Grant. Yeah, that's it. So let's get on the record. So looking at the offered evidence list, we've dealt with any omissions or corrections to the list, and we've discussed the comments that I've provided parties and commission staff. Most of the documents up until, well, direct and rebuttal and those exhibits, the opportunity to move to strike or object to those documents is over. But in terms of surrebuttal and surrebuttal, there's still an opportunity to request review of that before I enter them into the record. Were there any objections to the surrebuttal or surrebuttal and the connected exhibits? Nothing? Okay. So then I can say in terms of the offered evidence list, the documents listed here with the noted corrections, I will accept those into the record once they are verified, and they'll just need to be corrected according to our timeline that's already been put out there. And I think we can start and then I did want to mention that we did have the one issue that I mentioned in the 316 case was the legal issue that I had suggested parties brief. I just want to reiterate that I think it would be a good idea if they did that. You want to check back in the 316 transcript on what I'm looking for, but basically it's in terms of the obligation to serve does the context of this case trigger that obligation or not? And I'll just let parties address that or not. But I think it's an issue that would be useful for the commission in their review of the record. So let's continue, and we can take our first witness.
Thank you, Your Honor. Applicant will call Mr. Lambert. I just need to move out of the way.
Okay, and I'll try to adjust some screen names here. Where are you guys? And who's the attorney that's going to be presenting Lambert?
Your Honor, this is Lauren Rosso for applicant.
R-O-S-S-O?
That's correct, Your Honor.
Okay. All right. Got you all settled here, and I think we're good to go. So let's begin. We'll swear you in. Raise your right hand, witness Lambert. And do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yep.
All right, go ahead.
Mr. Lambert, did you submit rebuttal and rebuttal testimony in this proceeding?
Yes.
Did you also offer 8 exhibits?
Yes.
Is everything truthful and accurate to the best of your knowledge that you stated in testimony?
Yes.
And if I asked you the same questions that appear in your testimony today, would your answers be the same?
Yes.
This witness is available for press.
All right, I think AEU has questions.
We do, Your Honor. Thank you. Good morning, Mr. Lambert.
I'm sorry, I can't see a box who's speaking.
Oh, this is Nikhil Vijaykar on behalf of AEU.
That's fine. It wasn't lighting up on my end. I apologize.
Okay. No problem. Good morning, Mr. Lambert. How are you?
Well, thank you.
Nice to meet you. For the record, my name is Nikhil Vijaykar. I'm an attorney for Advanced Energy United. And I have a couple questions for you. I'll try to direct you to your testimony if I have specific questions about specific clients. Just let me know if I'm moving too fast. Now, Mr. Lambert, you are a lawyer by training, correct?
I went to law school.
Yes. Okay. And now you are manager, customer programs, and customer experience operations for WEC Business Services, correct?
Yes.
In that role, you say you're responsible for managing a portfolio of customer programs, including energy efficiency offerings, EV pilots, and other customer programs, such as budget billing, time of use, and green pricing. Do I have that right?
Yeah, that's what's in my testimony, I believe. Yeah.
Okay. Does your role require you to speak with the company's customers?
Yes, occasionally.
Uh, Give me a sense for how often you speak with the company's customers as a part of your role.
I guess I just asked, what context do you mean? Just speaking with any customer on any matter whatsoever?
Yeah, within your role at the company, how often would you say you speak with the company's customers?
I'll speak with customers on a regular basis. In addition, we have various customer service activities where I will review, listen to calls from customers coming in, as well as proactively reach out to customers to discuss many different matters in our customer program portfolio.
Is that
I guess I couldn't say specifically daily, weekly, but because it depends on the day of the week. But often I'll speak to residential or other customers.
I'm sorry, I didn't mean to interrupt you.
It's fine.
But thank you. You mentioned residential customers there. Do you also speak with your commercial customers?
Yes, as a matter of course, I will, at different frequencies, speak to various commercial customers.
Okay. And any industrial customers?
Yes.
So some of your customers, residential, commercial, or industrial, qualify for more than one of the programs that you manage, correct?
Sorry, can you say that again?
Let's read it back.
Sure.
Question. Some of your customers, residential, commercial, or industrial, qualify for more than one of the programs that you manage, correct?
Qualify for more than one? Some, yes.
Imagine some customers who qualify for your EV pilots, for example, also qualify for time of use pricing, correct?
Yes.
And presumably participating in more than one program can benefit your customers, correct?
Yes.
Do you take any steps to mitigate your customers' potential confusion when they're eligible for more than one customer program?
Yes.
Now, your testimony is that if a utility tried to dramatically increase energy efficiency programs in addition to what Focus on Energy offers, it would likely lead to increased administrative costs and customer confusion. I can point you to a specific place, but would you agree that's your testimony?
Well, let's take a look, but yeah.
Sure. Yeah, I'm looking at page 9, lines 3 through 8, 3 through 8, and I believe that's of your rebuttal testimony.
Yep.
Okay. And I'll just say this, if you agree with it, good. Otherwise, we can consult testimony. But your testimony is also that if significant new energy efficiency programs were offered that offered incentives on measures that are already incentivized by Focus on Energy, that would cause confusion and potentially detract from both programs. Would you agree that that's your testimony?
Well, let's take a look if you're referencing something specific, please.
Not a problem. This is now your sir rebuttal testimony. And I'm looking at lines 4 through 6 on page 3 of your sir rebuttal testimony.
Yeah, that's correct.
You use the word detract. What do you mean by detract? Do you mean dampen participation?
probably detract in the sense of reducing the potential savings possibility of both programs.
Reducing the possible savings opportunity for the customer or for the program overall?
Yeah,
what do you mean?
Overall, I guess this relates, as most of my testimony does, back to the chosen statewide utility program structure in Wisconsin, where the state of Wisconsin has chosen to have the statewide utility programs operate through focus on energy rather than individual utility basis. And so I think that since the focus on energy program has been a successful and cost-effective energy efficiency program, the proper place to add energy efficiency is through that utility program structure rather than 100 plus utilities offering additional utility programs on top of an existing program, statewide structure.
Okay, so let's focus on no pun intended there with focus. Let's not think about 100 new utilities offering new programs. Let's talk about a scenario where WEPCO, where the applicant were to offer an incremental program in addition to what Focus on Energy is already offered through Focus on Energy. When you say that possibility would potentially detract from the program, I'm trying to understand if it's your testimony, if it's your position, that offering that program would reduce the savings that could be achieved from Focus.
Objection to the extent this calls for an incomplete hypothetical.
Your Honor, I'm not sure what's incomplete about the hypothetical, but if there's something that Attorney Rosso would like me to supplement, I'm happy to do that to round out the hypothetical.
Yeah, I think we are missing some details. Would you mind, Madam Court Reporter, just reading the question back?
Question,
let me just so I'll direct the court reporter to read that back. So if you want to have the court reporter do something, you'll need to ask me. So just
Okay.
a practice tip. Okay. Go ahead.
Okay. Question, let's focus on, no pun intended here, with the, I'm sorry, with the example. Let's not think about 100 new utilities offering new programs. Let's talk about a scenario where WEPCO, where the applicant were to offer an incremental program in addition to what Focus on Energy has always offered by Focus on Energy. When you say that possibility would potentially detract from the program, I'm trying to understand if it's your testimony, if it's your position, that offering that program would reduce the savings that could be achieved from this.
Your Honor, may I proceed with explaining my objection?
Sure. Go ahead.
So it was to the language incremental program. I just think that's vague. I don't know what program or what that program would look like.
May I respond, Your Honor?
Yes, go ahead.
Mr. Lambert, in the section of the testimony that we were just looking at, the question references additional energy efficiency programs on top of what Focus on Energy offers. So where my hypothetical references an incremental energy efficiency program, I think that's what I was referencing. Okay.
All right, so I'll overrule the objection. You can answer the question. We've had it read back once, but do you need it read back again?
Yes, Your Honor, if you don't mind.
All right, go ahead. Read that back, please.
Sorry. Question, let's focus on, no pun intended there. Let's not think about 100 new utilities offering new programs. Let's talk about a scenario where WEPCO, where the applicant were to offer an incremental program in addition to what Focus on Energy has offered by Focus on Energy. When you say that possibility would potentially detract from the program, I'm trying to understand if it's your testimony, if it's your position that offering that program would reduce the savings that could be achieved from this.
Yeah, I think, yes, in general, from the customer confusion and additional programs being out there on a much more complicated horizon for customers. Yes.
So are you concerned that certain customers that would have participated in Focus on Energy would not participate in Focus on Energy if they had another offering available?
I think the most effective way to increase energy efficiency is to have the conversation resolve around the existing defined statewide utility program and Focus on Energy. But yes, I believe that it could detract from customers taking advantage of opportunities due to customer confusion and the complexity of poor results.
Okay, Mr. Lambert, give me an example of a residential measure that's already incentivized by Focus on Energy.
I'm sorry, can you give me an example?
Yes.
Can you finish?
I think you need to repeat that question.
Yeah.
Sure. My question was, give me an example of a residential measure that is already incentivized by Focus on Energy.
Sorry, I don't understand. You just want me to give you what? Just name any of the measures that are incentivized?
Yes, residential measure.
I would ask that you reference a list from your sources. The measure names, I think Focus calls them measure master names or measure master identifications for Focus, are fairly complicated and long. I think there's over 30 just for smart thermostats alone.
Let's take, for example, a lighting measure. Is that simple enough? Do you understand when I reference a residential lighting measure, what that might look like?
I understand the category, but I don't think that that necessarily describes the specific measure you're wanting to get to. There are many different types of lighting, efficiency lighting measures that can be done, and the industry and building type. I think, again, I don't even know how many lighting measures there probably are in the Focus on Energy Technical Reference Manual, but there are many.
Understood. Mr. Lambert, you're a utility customer, is that correct?
Yes.
Have you ever
sorry, just to clarify, electric, natural gas, yes.
Thank you. Yeah, I should clarify, electric utility customer, correct?
Yes.
Have you ever participated in a electric utility, electric energy efficiency program?
Yes.
Was that program offered by Focus on Energy?
Your Honor, I'm just going to object to this line of questioning to the extent it's not relevant to Mr. Lambert's testimony. He is not testifying as a customer, but rather in his employment capacity with Wisconsin Electric.
I'll overrule it for now, but I think I want to be careful to stick to the expertise of the witness.
Certainly, Your Honor.
Do we need a read back? Is there a pending question?
Yes, please, Your Honor.
Let's read back that question.
Question, was that program offered by Focus on Energy?
I've taken advantage as a residential electric customer of a number of energy efficiency savings opportunities. I can't think of all of them off the top of my head, but yes, I have taken advantage of Focus on Energy incentives.
Okay.
As an electric customer. Sorry.
No problem. Thank you. And if WEPCO were to offer an additional incentive on the same measure that you benefited from a different program, do you believe that would confuse you, Mr. Lambert?
objection, incomplete hypothetical, confusing form, and relevance again.
Okay, if you could rephrase the question, I think that would be helpful.
Certainly, Your Honor. I'll rephrase the question. My question is, if WEPCO offered an additional incentive on a measure that you had already participated in through focus, would that confuse you, Mr. Lambert?
Same objection, Your Honor. Additional incentive is unclear, especially when Mr. Lambert has discussed multiple measures.
Well, Your Honor, the portion of Mr. Lambert's testimony that where this line of questioning started references additional energy and efficiency programs offering incentives on measures that are already incentivized by our utility program focus on energy.
Yeah,
I'll
allow the question. Can you answer? Do you want to read it back?
I would love it to be written back.
All right, great. Did you have your coffee this morning?
I did. Just
all
want
right.
to make sure I'm answering the question.
Yes, I know. I'm just kidding. And I appreciate you being diligent about it.
My question is, if WEPCO customers could have offered an additional incentive on a measure that you had already participated in through focus, would that confuse you, Mr. Lambert?
If WEPCO is offering additional energy efficiency measures, I would likely be the program manager for those measures, having been involved in the program design. So I personally would likely not be confused. However, as a customer, it would add additional complexity in the research and working with contractors and many others. So that complexity would leave open the opportunity for missing an incentive or to not have as much understanding of what is out there for our customers in an already multi-layered landscape of incentives.
Mr. Lambert, what could WEPCO do to manage that potential for misunderstanding?
Ensure that in measures related to items that are already incentivized by Focus on Energy are incentivized through the statewide energy efficiency utility program and not adding the additional complexity through adding duplicative incentives through utility specific offerings.
Now, you say, Mr. Lambert, this is now at your Sir rebuttal testimony at page 4. I think you say that the company currently makes efforts to minimize customer confusion. Do you see that?
Yes.
And is it your position that the company cannot expand those efforts to minimize customer confusion?
We've consistently taken the opportunity to expand where we see opportunities to making sure our customers are aware of the Focus on Energy program and any other opportunities so that they can understand their energy use and be in the best position to save energy on their energy bills.
And you would continue to do that going forward?
Yes.
So in other words, the company has the opportunity to expand its efforts to minimize customer confusion?
I would repeat my statement from a little bit ago that we've consistently where we identify opportunities, we will make sure to help customers with education and information on opportunities to save energy.
Okay. That's all I have, Your Honor. Thank you, Mr. Lambert.
All right. Does anyone else have cross for witness Lambert?
Yes, Your Honor. Cub has one question for Mr. Lambert.
Hang on, I'm going to switch out to my screen here and get you in there. All right, great. So just introduce yourself to the witness and go ahead.
Yes, thank you. Good morning, Mr. Lambert. Corey Singletary on behalf of the Citizens Utility Board. I just had one question, just so I'm clear on what you mean in the words that you've used in your discussion with Mr. Vijayekar this morning. I'm just going to refer you back to your, I believe it's your Sir rebuttal on page 3, lines 4 through 6, where you say that significant new energy and efficiency programs offering incentives on measures that are already incentivized by our utility program focus on energy would cause confusion and detract from both programs. Do you recall that discussion?
Yes.
Okay. I just want to understand better. When you say detract from both programs, is it your testimony that the end result would be a net total reduction in the amount of energy efficiency savings?
No, I don't have any information on what the result would be.
Okay, thank you. That's all from Cobb.
All right. Any other parties? Questions for the witness? Commission staff? Nothing? All right. Thanks. I'll redirect. Go ahead with redirect.
No redirect, Your Honor. Thank
All
you.
right. Thanks. All right, great. You're excused. Thanks very much.
You.
This list is longer than I was expecting. Okay. Who do we have next?
Your Honor, we are switching again, but applicant calls Jody Arndt to the stand.
Carefully type your name in. See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I'm sorry, I couldn't hear you.
I do.
Thank you.
Great, thanks. I'm gonna switch out our attorney name here. All right, go ahead.
Thank you, Your Honor. Good morning, Mr. Arndt. Would you please state your name for the record?
Jody Arndt.
And Mr. Arndt, did you prepare and cause to be filed direct, rebuttal, surrebuttal, and surrebuttal testimony?
I did.
And if I asked you the questions contained in your testimony today, would your answers be the same?
They would.
Did you prepare and cause to be filed 16 exhibits and 1 delayed exhibit?
Yes, I did.
And are those exhibits true and correct to the best of your knowledge?
Yes, they are.
And subject to some of the corrections that we've discussed off the record, are there any other changes to your testimony or exhibits today?
No.
Your Honor, Mr. Arndt is available for cross-examination.
Okay, look like AU had questions.
I do, Your Honor. Thank you. Good morning, Mr. Arndt. It's nice to meet you. My name is Nikhil Vijayakar, and I am attorney for Advanced Energy United. How are you?
Good. Good morning. Thank you.
Good morning. My questions will relate in part to your direct testimony. Do you have that available to you?
I do.
Mr. Arndt, you are the Director of Planning for WEC Energy Group, is that correct?
That is correct.
Page 2 of your direct testimony, you say in your role, you're responsible for planning, contracting strategy, logistics, and all aspects of future planning for WEC, with particular emphasis on supporting WEC's generation reshaping plan. Do you see that portion of your testimony?
Yes.
You say supporting WEC's generation reshaping plan. It's fair to say you were involved in developing that plan, correct?
Correct.
Would you say that you were the chief architect of that plan?
No, I would not. I would say I was part of a supporting cast and helped hold it together.
Okay. But you're familiar with the development of the GRP, correct?
Correct.
Let's turn to page 12 of your direct testimony. And I apologize, I'm looking to the left because that's where I have your testimony. Don't make me be rude. On page 12, you testify that WEPCO will need to build a substantial amount of additional generating capacity over the next few years to reliably serve its customers. It's lines 3 to 4. Do you see that?
Yep, correct.
And a couple lines down, you say that to address their substantial capacity needs, Wisconsin Electric and WPSC developed a diverse portfolio of new generation and to address a series of goals. Do you see that?
Yes, correct.
Now, presumably the company conducted some modeling to develop the optimal resource mix to meet those incremental capacity needs, correct?
We apply many tools and techniques looking at, in order to meet all of those goals that we have. So modeling is a part of that.
And there are tools and techniques other than modeling. Is that what you're referencing?
Correct.
You estimate 1,900 megawatts of additional generation resources by MISO planning year 2026, even with flat or slightly declining load projections. Do you see that?
Yes, correct.
So what I'm trying to understand is what portion of the company's substantial capacity needs, that's your terms, will be met through utility-owned generation as opposed to purchase power or other non-company-owned resources?
Can you say that again?
Let's have read it back.
Question. So what I'm trying to understand is what portion of the company's substantial, capacity needs, that's your terms, will be met through utility-owned generation as opposed to purchase power or other non-company-owned resources.
Within the portfolio now, we do have a purchase power agreement for the offtake of the Point Beach nuclear plant. As we looked at the rest of the portfolio, we looked at our ownership model as being the preference for various reasons.
How is that preference incorporated into your modeling for the GRP, Mr. Arndt?
Objection states facts, not evidence.
Can I restate my question, Your Honor?
Go ahead.
Is that preference reflected in your modeling for the GRP, Mr. Arndt?
Yes, I believe it's inclusive in the process and included in the modeling.
How is it included in the modeling?
With the various assets we have that we look at a number of different characteristics for those assets. Each one are different. And then we look across the spectrum to see what is available to meet those needs. And then we look at the costs associated with that. We look at the strategic advantage of ownership, and we build that into looking at the cost and the mix of the assets needed to reliably serve the portfolio.
Now, Mr. Arndt, you referenced a PPA for offtake from a nuclear plant.
Correct.
Is that the only purchased power among the set of resources that the companies will be using to round out its generation reshaping plan?
Currently in front of us, yes, as far as what we have to date.
Okay. Mr. Arndt, let's look at the application. Do you have that available to you?
Don't know.
I guess that is. We can pull it up on the screen, I suppose. But I'd like to look at page 2-15 of the application.
Go off the record for a second, and we could do this in public, the public version.
Yes. Yes.
Right.
Thank you, Your Honor.
And it's page 2-15.
Page 2-15.
See if searching will work. Oh, looks like it's going to work. Okay. So are we in the right place?
We are.
Okay, great. Okay, let's get back on the record. And does the witness, are you using the screen share or do you have your own? You are, okay.
Yep.
So just let me know if you can't see something or if, I can adjust the screen better for you.
Looks good. Thank you.
Mr. Arndt, do you see where it says, while Wisconsin Electric considers and evaluates market alternatives, including proposals from IPPs, a purchased power agreement, open paren, PPA, close paren, does not provide the level of control ownership does, while addressing reliability and resiliency of the utilities systems. You see that?
Yep, correct.
What are market alternatives in that sentence?
Well, market alternatives in which follow, right, including proposals from IPPs, purchase power agreements, and ultimately the market itself.
What purchases from MISO?
Correct. Market purchases from MISO.
And so this statement that I just read that you and I are looking at, this statement applies to the development of the GRP, correct?
It involves our planning process in totality, not simply quote unquote the GRP, but our planning philosophy.
Okay, so the GRP, but not just the GRP, the planning philosophy more broadly. So WEPCO considers and evaluates market alternatives as a part of developing the GRP. Is that what I understand from the sentence that I read?
Correct.
I'm trying to understand what you mean by considers and evaluates. Does WEPCO issue RFPs as a part of developing the GRP?
Well, if you read the paragraph below that, I think we, clearly talk about PPAs and the preference towards ownership and the reasons for that. So if a alternative would come to us where we would like to pursue and don't feel comfortable from an ownership standpoint, we absolutely would consider that.
But it doesn't issue RFPs as a part of considering and evaluating market alternatives, correct?
For traditional resources that we are comfortable with from an operational maintenance standpoint, that is correct.
The end of the sentence that I read, Mr. Arendt, references the reliability and resiliency of the utilities systems. You see that?
Correct.
Now, as a part of developing the GRP, you don't, or you have not analyzed the reliability risk of PPAs, correct?
We have a lot of experience in the past with PPAs that we've been involved with, and we understand some of the risks associated with those PPAs. So while we didn't have a PPA in front of us to evaluate that specific asset that we may have looked at in the GRP, we have a lot of experience in PPAs and some of the challenges and the risks they offer.
Okay. Any quantitative modeling of the risk associated with the reliability or resiliency risk associated with PPAs as a part of developing the GRP?
No, we do not have quantitative, more qualitative.
Okay. No further questions, Mr. Aaron. Thank you for your time.
Okay. Anyone else with questions?
Yes, Your Honor, the commission has one question for Mr. Arndt.
Okay, let me just adjust what I'm seeing here. Just a second. All right. Okay, introduce yourself to the witness and go ahead.
Hi, my name is Stephanie Bedford. I'm Assistant General Counsel for the Public Service Commission of Wisconsin. Good morning.
Good morning.
The question that I have for you refers to your rebuttal testimony at the top of page 5. Do you have that available for reference?
Yes, I do.
Certainly. So at lines 1 and I guess 1 through 3 of page 5, you state that the 1,100 megawatts of the Oak Creek combustion turbines would need to be replaced by nearly 6,500 megawatts of solar and storage to meet an equivalent amount of energy demand in the summer.
Correct.
Yes. So my question is, how many megawatts of that 6,500 would be for solar, and how many of that 6,500 would be for battery storage, in your best estimate?
Oh, yeah, I don't have the total in front of me, but trying to recall, if it was in prior testimony, where it might have been in my direct where we actually went through the calculation and looked at the how we came up with that number. I have to go back. Yep, it's under direct. Sorry, as I'm paging through.
No worries.
Go off the record till you find it.
Yeah, we didn't break it out specifically. We included it as one.
I think are we off the record or on the record?
Or off. We're off.
So I think Mr. Arndt has it in front of him and would be prepared to answer the question on the record.
Okay. All right. Yeah, let's get on the record.
Yep.
Are you prepared to answer the question, witness Arndt?
Yep.
Go ahead.
Yep, it's roughly 50%. So it's roughly 50% solar, 50% battery.
I'm sorry, at the end of that, I didn't hear you.
It's roughly 50% solar, 50% battery.
Thank you.
So just curious, you said you were referencing your direct testimony. Where would that information be located?
It's on page 31. So it talks about the equivalent of a megawatt of capacity. You would need 2.9 megawatts of capacity of solar, and spread across 24 hours would require 2.8 megawatts of 4-hour BES. So roughly 50%.
I'm sorry, I think Mr. Arndt misspoke. It starts at 30, goes on to 31.
Yes.
Thank you. Okay.
Thank you. No more questions.
Okay, thanks. All right, other questions from other parties? No? All right, redirect.
No redirect, Your Honor. Thank you.
All right. Thank you very much then. You're excused.
Thank you.
Your Honor, applicant calls Mr. Brandon Gerlikowski.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Go ahead.
Thank you, Your Honor. Good morning, Mr. Gerlikowski. As part of your testimony in this case, did you prepare and cause to be filed direct, rebuttal, surrebuttal, and surrebuttal testimony?
I did.
And subject to an errata to your direct testimony and some corrections we discussed off the record, if I asked you the questions in your testimony today, would your answers be the same?
They would.
And Mr. Gerlikowski, did you prepare and cause to be filed 10 exhibits, including 2 exhibits with your surrebuttal?
I did.
And are those exhibits true and correct to the best of your knowledge?
They are.
Thank you, Mr. Gerlikowski. Your Honor, Mr. Gerlikowski is available for cross.
All right. It's like commission staff.
Yes, Your Honor, and I believe we'll need to do our cross-examination in camera for this witness.
Yes. All right. Not a problem. Let me just, well, I think I'm going to just remove that. So let's go off the record. So I believe we did this correctly last time. I'm just moving everyone to, well, I think I'll just create a room. I think you'll need to go into it to, if you're authorized to hear the confidential. So let's start that. So you should have an invitation to join the room.
Yeah, I'm not seeing that invitation.
It's tiny at the bottom of your screen. I just
Oh,
found
I
it.
see. Join a breakout room.
Yeah, I don't see it. This happened to me last time. I may be a little late. Trying to unpin you, Attorney Vijayekar. Oh no, okay. I don't know why you're front and center here. As far as I know, I don't have you set up to do that. It's weird. There we go. Get changed again. And people still in the breakout room. I think I can just close the room. When
I clicked on leave, it clicked me out.
Yeah, it clicked you out complete. Oh, because you left the meeting. Yeah.
Well, that was the only option.
It was? No.
Yeah, when I clicked on leave, it said leave the meeting, and I'm like, well, how do I go back now?
Oh, it gives you choice, I think, but
mine didn't.
Okay. I'm just
So
gonna
maybe
close.
there's a leave breakout room. I see there's a join breakout room, so maybe I
Yeah.
looked at the wrong,
There is a leave. Well, let me close the room and see what happens.
not the little man walking through the door.
Ah, there we go. Closing the room brings everyone back. I should just take it over. Three names are changed.
My apologies, Your Honor. I had the same issue.
No worries. I'm surprised we don't have more practice in this.
So, Your Honor, did you ultimately close the breakout room?
Yes.
Okay.
I think that actually just brings everyone back.
I think on our end as participants, we just get the leave option, which kicks us all the way out of Zoom.
Yeah, I haven't seen that before. That's okay.
Probably a fancy Zoom update that we all got that's really helping us out.
Yeah.
Anyway, thank you, Your Honor.
There we go. All right. I'm just moving people over. Okay. And it's listing people in both places now. I think everyone's in the main room here. Times here. Yeah. I don't know why it's got people in both the breakout room and the main room. But I think everyone's here with us now. So we had more questions from
back on?
No, not yet. But more questions from Attorney Bedford?
No, no more questions, Your Honor.
Oh, okay. Sorry. I thought you mentioned that. Okay. Well, let's get on the record then. Okay, so we have no more questions from Attorney Bedford. Any other cross for the witness? Public cross? No? Oh, is it Sierra Club have a question?
Yes, so this is for witness Gerlikowski.
This is for, yes, Gerlikowski.
Okay, I have very brief cross if I may, Your Honor.
All right, so just introduce yourself and go ahead.
Hi, I'm Megan Waxpress. I'm an attorney for Sierra Club in this proceeding. I have a question about response PSCW Bushy 7, PSCW DG 7.01. I don't know if I need to circulate that. I'll be relying on the redacted public version.
Okay, let me return to our list here. And I'll get the screen share up as well. Let's see, you'll have to just give me that name again for the data request.
Yes, it's PSCW DG 7.01.
Okay. Let me get the screen share going. Is this what we're looking for? Relates to the modeling cost.
Yes.
Okay. So so which document should we bring up? There's
532510.
Okay. Carefully. There we go.
And I want to ask about something on the second page, towards the middle of the page.
That's got all the good stuff.
Hmm.
Oh,
So,
hang on. All right, so let me get you on the screen now. I need to just be able to see everybody. Got... There's our witness. There you are. Okay, excellent. Go ahead.
okay, so I'd like to direct your attention to the sentence, using the same methodology for calculating the equivalent rate that was used for calculating Bluff Creek LNG's equivalent rate yields a redacted rate for the Oak Creek LNG. Have I read that correctly?
Yes.
And the Bluff Creek LNG equivalent rate.
I'm sorry, the what creek?
The Bluff
Creek
LNG equivalent rate is based on a cost allocation rate methodology in which all firm gas customers pay for the revenue requirement associated with the Bluff Creek LNG. Is that correct?
The equivalent, I wouldn't say it's as you stated. The rate that we calculated is based on the characteristics of the Bluff Creek LNG facility. So using the capital cost, fixed O&M, and the equivalent withdrawal capability of it to develop a $1 per decatherm day rate, and then utilizing that rate for the firm requirement needs of the Oak Creek CTs.
Does that $1 per decatherm rate assume that the entire cost of the LNG facility will be paid by WEPCO as a firm gas customer?
In the analysis, yes, it would assume that the Oak Creek CT would pay for the requirements, whatever the requirements are of the Oak Creek CT. So then that calculation would yield the fixed cost that we included in the model.
I think I wasn't clear. I'm asking not about the cost of the CT, but the cost of the LNG facility.
The rate itself covers the cost of the LNG facility.
So the full cost of the LNG facility would be covered by the rates that are redacted here, but that were used for the modeling of firm gas delivery rates.
Yes, that's correct.
Okay, thank you.
Okay. That's it for Sierra Club. Any other cross? Redirect on this?
No, Your Honor. Thank you.
Okay. Thanks very much. You're excused.
Thank you.
The Honor applicant was going to call Mr. Haggerty. And we'll just.
All right. Oh, you're switching it all up on me. Okay. We're good. Let's get started. I'll swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead.
Please state and spell your name.
John Michael Haggerty, Haggerty.
Did you prepare and cause to be filed direct rebuttal, sur rebuttal, and sur rebuttal testimony and accompanying exhibits in this case?
Yes, I did.
Do you have any corrections to your testimony?
Yes, I have one correction. In my sur rebuttal on page 13, line 2. The end of that sentence says confirming that may conclusions. The correction is confirming that my conclusions. So may should be changed to my.
Subject to that correction, if I asked you the questions contained in your testimony today, would your answers be the same?
Yes.
Mr. Haggerty is available for cross.
Right. AEU questions?
Yes, Your Honor. Just a couple questions. Good morning, Mr. Haggerty. How are
Good
you?
morning. Doing
My
well.
name is Nikhil Vijayakar. Doing well. Thank you for asking. My name is Nikhil Vijayakar. I'm an attorney for Advanced Energy United. Just a couple questions about your sur rebuttal testimony. I'll ask you to turn to page 6, that testimony.
I'm there.
Great. And I'm at line 17. And there you say, however, the MISO market only needs so many fast ramping resources, and the market value of those resources is unlikely to overcome the cost savings of the OCCT project. Do you see that?
I do.
Okay, so you're saying that if the entirety of the OCCT project were replaced by battery energy storage systems, the market value of those battery resources is unlikely to overcome the cost savings that would have accrued as a result of OCCT, correct?
Can you restate that, the beginning of that?
Let's read it back.
Question, so you're saying that if the entirety of the OCCTC project, I'm sorry. I'm sorry, everything kind of piled on one here and I don't know what the words are.
Okay, well, let's just have you restate the question then.
Sorry.
Not a problem. And since Witness Haggerty asked me to restate, I'll ask it differently. Mr. Haggerty, my question is, are you saying that if the OCCT project were replaced by battery energy storage systems, or BESS, the market value of those resources is unlikely to overcome the cost savings that would have accrued as a result of OCCT? Is that correct?
I was saying that the faster response of battery storage
relative to the OCCT, which also has its own ability to respond quickly to market events, that incremental value that the BESS provides, not the full market value, but the incremental value, would be unlikely to overcome the cost savings that Wisconsin Electric identified in their modeling of the OCCT relative to the BESS.
Okay. And your comparison is the OCCT project in its entirety to a BESS resource that provides an equivalent capacity. Is that right?
Yeah, equivalent nameplate capacity. That's correct.
Okay. Now let's go down to page 7, line 9 of the same testimony. And here you say the faster response time of BESS can earn greater revenue in the regulation market compared to CTs, but the larger penetration of BESS projected for MISO will exceed demand for regulation and limit revenues of any single BESS resource, such that the additional regulation revenues that BESS can receive are likely to be short-lived. Do you see that?
I do.
Now, when you say projected for MISO, you're not referring to a projection you have provided with your testimony, correct?
I'm not. I'm referring to what I've seen in the amount of storage that's in the queue, as well as the amount of storage that's been included in some of the MISO projections through the futures scenarios.
Okay, so based on what you've seen, when will the penetration of BESS and MISO exceed the demand threshold you're referencing here?
I have not evaluated that specific question, but I've seen this in several other markets where there's initial value of regulation, but that gets reduced after several years of penetration of storage.
Well, let's talk about those other markets. You say after several years of penetration of storage. How many years in one of the markets that you're referencing?
I would say, it depends on the rate of storage additions. But generally, once we've seen storage additions in markets like CAISO and ERCOT, it's increased significantly in 2 to 3 years. And by the end of that period, we've seen ancillary service revenues, specifically regulation of storage, start to decrease.
Just off the record for a second. Are you still answering? I'm sorry.
I was, sorry.
Oh,
sorry for the pause.
No, go ahead. Go ahead. Back on the record.
Due to the amount of capacity that's entered was all I was going to add.
Yeah, just off the record, I wanted to, you had one acronym there I couldn't hear. It's right before ERCOT, and
CAISO, the California Independent System Operator.
Okay, just want to make sure we get that correct. Thanks. All right, back on the record.
And Mr. Hagerty, to your knowledge, WEPCO hasn't offered any analysis comparing the reliability services revenue of the OCCT project and the potential reliability services revenue of a BESS, correct?
When you refer to reliability services, do you mean ancillary services in the MISO market?
I do. I'm using that term as you used it in your testimony, but I do.
Okay, I used both in the sentence that's before us, so they have not.
And you haven't conducted that analysis, have you?
I have not.
Okay, no other questions. Thank you, Mr. Hagerty.
All right. Other questions for the witness? It's a Clean Wisconsin of questions.
Yes, Your Honor.
Okay, let me just adjust my screen. Okay. All right, go ahead. Just introduce yourself and proceed.
Good afternoon now, Mr. Hagerty. I'm Brett Cordy with Clean Wisconsin. I have a couple questions for you about your, based on your rebuttal testimony. On pages 24 through 28 of your rebuttal testimony, you discuss interveners' arguments that WEPCO should increase demand response. And specifically on page 25 of your rebuttal, starting on line 4, you say that, quote, demand response in the Wisconsin electric territory cannot be accurately included to a greater extent in capacity expansion analyses like those relied upon by Wisconsin Electric and Clean Wisconsin in this docket. Do you know what percentage of WEPCO's peak system demand Clean Wisconsin witnessed hoteling modeled as demand response?
I do not.
And Mr. Haggerty, you're a principal for the Brattle Group, is that correct?
I am.
I'd like to turn to one of the documents we provided to staff and parties yesterday titled The National Potential for Lead Flexibility, Value, and Market Potential through 2030. Are you familiar with this document, Mr. Haggerty?
I am.
This document was prepared by colleagues at your firm, the Brattle Group, correct?
That is correct.
I'd like to look at page 5, PDF page 6 of this document. Mr. Haggerty, this graphic shows that your firm identified demand response capability in Wisconsin as greater than 10% of system peak. Is that correct?
Sorry, I missed what aspect, how you referenced to the amount in Wisconsin. Could you repeat that portion of your question?
Yeah. This graphic shows that your firm identified demand response capability in Wisconsin as greater than 10% of system peak. Is that correct?
That is correct. But I would highlight that this was a regional analysis that was allocated to the states that seems to, based on the coloring, to include Wisconsin, Minnesota, and Iowa. That it was not a Wisconsin specific analysis.
Understood. Thank you, Mr. Haggerty. I'd like to offer this document as Exhibit WEPCO Haggerty. I think we're at 19.
We can mark it as 19. That'll be the, back to this, the National Potential for Load Flexibility, authored by the Brattle Group. Any objections to receiving that document? Okay, we'll put that in.
Thank you, Your Honor. Mr. Haggerty, next I'd like to turn to the other document I provided yesterday, which is titled The Potential for Load Flexibility in Xcel Energy's Northern States Power Service Territory. And Mr. Haggerty, are you familiar with this document?
I am. I believe I included it as a exhibit or as a source in one of my testimonies in this document.
Thank you. May have missed that. We'll have to double check before I offer it as an exhibit. But this document was also prepared by your colleagues at the Brattle Group, correct?
Yes.
If we could go to figure 1 on page 3, PDF page 14 of this document. Figure 1 shows that in 2017, Northern States Power had 850 megawatts of demand response capacity, or approximately 10% of system peak demand. Is that correct?
Yes.
And if we can go to figure 5, which is on page 16, PDF page 27 of this document. Brattle Group identified an additional 293 megawatts of demand response NSP could cost effectively implement by 2023. Is that correct?
That's correct, primarily by expanding existing programs.
Thank you. I'd like to offer this document as WEPCO, Exhibit WEPCO Haggerty 20 if it wasn't already submitted. I apologize for that oversight.
Okay, I'll mark it as 20, and it's the potential for load flexibility in Xcel Energy's Northern States Power Service Territory, dated January 2019, again by the Brattle Group. So, any objections to letting this in, pending a review, whether it's already been offered? Haven't seen that. No objections, so we'll put it in there, and if we can just review that before we file, just make sure it's not already in the docket. I know I've seen this document before, but I don't remember which context it was in. Maybe it was just in the NSP case. Okay, so and I would, the way we usually handle that is the party that's producing these documents would file. So if you could do that, double check that, Attorney Cordy, before you do file. And then if there's a chance that it's already in the record, just send us all an email to that effect.
Will do. Thank you, Your Honor. No further questions.
Okay, great. Thanks. Okay. Anyone else have questions for witness Haggerty?
Your Honor, this is Matt Frank from WLGCC. I have a few questions.
All right, go ahead.
Thank you. Good afternoon, Mr. Haggerty. I'm Matt Frank. I'm an attorney for Wisconsin Local Government Climate Coalition. I just have a few questions. Is it your opinion that you agree with the interveners in this case that demand response can be a cost-effective resource to be considered to provide power in the future?
I agree, and have stated in my testimony that demand response can be a cost-effective resource.
And that's been demonstrated by studies around the country that you referenced in your testimony, correct?
Yes.
But I believe you've also have stated that studying the role of demand response in Wisconsin would require more time and effort than is devoted to the capacity expansion analysis that has been done by Wisconsin Electric. Is that correct?
It would take additional effort to develop accurate and reasonable assumptions that account for the capability of a diverse set of demand response.
And would you agree that Wisconsin Electric at this point does not have any accurate assumptions for the costs, operational capability, or potential scale of demand response programs?
Based on my understanding, I've not seen extensive analysis. I know that they're undertaking a pilot study currently for their Bring Your Own Device program that can be a source of that type of information.
But would you also agree that to fully explore demand response, We Energies would need to complete a more comprehensive analysis of the potential for demand response than what exists currently?
I would agree with that.
Thank you. No further questions.
Okay, any other cross? No? All right, redirect.
Yes, Your Honor. Just a couple. Mr. Haggerty, you've been asked questions by Attorney Cordy and Attorney Frank about demand response programs for other utilities. Do you recall that?
I do.
Are demand response programs implemented by one utility necessarily translatable to every utility?
Not necessarily, not the exact same capabilities or costs, which is why it needs to be a utility-specific analysis.
Are the results of demand response programs at one utility in terms of reduction in load necessarily translatable to every utility?
Not necessarily.
You were asked by Attorney Cordy about a Brattle report having to do with demand response. I believe it was from January 2019. Are you aware whether MISO is currently studying the role of demand response in generation portfolios going forward?
Yes, they are.
And what's your understanding of the direction of that analysis?
My understanding is that MISO is trying to more accurately capture the reliability contributions of demand response by specifying several categories of demand response, increasing the requirements to test and ensure that those resources are available when needed. And generally, this is expected to decrease the capacity accreditation of demand response resources in MISO.
Nothing further.
I just had one follow-up question for the witness. Just looking at the potential load flexibility study, I think we've marked that at least provisionally as your Exhibit 20. Any idea how long this study took to create, to produce?
I would estimate that it's from, when you say how long, do you mean from like initiation of the study or the outreach by the utility? What's your definition of a length?
From when you were contracted to produce it till the finished result?
I would say 6 months to a year.
All right, just curious. Thanks. Any follow-up on that?
Your Honor, I have a little follow-up.
Oh, boy. All right, go ahead.
I'll be short. I'm sorry.
No, it's okay. It's my fault.
Well, I guess I would just want to follow up on Mr. Haggerty. You've testified that to properly study demand response programs, you really need to do that on a utility-specific basis. Am I understanding your testimony correctly?
That's right.
Are you familiar with Mr. Lambert's testimony in this proceeding that further investments in energy efficiency and demand response should be made through the Focus on Energy program on a statewide basis?
I am familiar with that, yes.
So can you explain how would that work on a statewide basis if demand response should be looked at on a utility by utility basis?
Objection. This is, I think, outside the scope of this witness's testimony. If you want to ask Mr. Lambert about it, that's okay, but I don't.
Well, let me ask you this. Do you disagree, Mr. Haggerty, with Mr. Lambert that demand response should be looked at on a statewide level as opposed to a utility level?
I have seen statewide studies that account for the differences across utilities. I don't fully, I'm not fully aware of all the relationship between the utilities and Focus on Energy, so it's where I would definitely defer to Mr. Lambert. But I think there's a statewide study could be done that accounts for differences across utilities.
But in the end, I assume, Mr. Hagerty, you still believe that the best study of demand response is done on a utility by utility basis?
I think any study that accounts for the specific customer types and rate designs and the several differences across utilities would be able to capture the role of demand response across state or utility.
And at this point, Wisconsin Electric hasn't undertaken any of that kind of study looking at the future potential demand response, correct?
Objection, calls for speculation.
Yeah, I agree.
Well, I think he's already answered in his previous testimony. I have no further questions. Thank you.
Okay, thanks. Any redirect?
No, Your Honor. Cub has some follow-on from Attorney Wilson's questions.
Okay. I guess make it quick, please.
Yeah. Just real quick. Good afternoon, Mr. Hagerty. Attorney Wilson asked you a question about demand response programs in other state, and I forget exactly the precise wording he used, but he basically asked you whether or not demand response programs from other states could necessarily, be transferable to another state. Do you recall that discussion?
I do.
Okay. In the absence of the type of analysis that you were just discussing with Mr. Frank, could information about demand response programs from other states provide useful inputs into the type of analysis for resources and resource requirements?
I'm not sure what you mean by useful inputs. I think they can demonstrate the potential role of demand response, that it's, but not provide the level of specificity and accuracy that you would want to include in a resource planning study, where you would be choosing demand response over a different type of resource.
Okay, no, that's helpful. Thank you. And then Attorney Wilson also asked you a question about changes or pending review of demand response resources before MISO. Do you recall that?
I do.
Yeah, and I believe you had indicated that your understanding was that those changes would reduce the accredited capacity for demand response resources. Do you remember that?
Yes.
Based on your understanding of that process before MISO, is it the case that those revised demand response rules would preclude the development of new demand response programs consistent with those new rules?
Objection, calls for speculation. The rules aren't finalized yet.
I'm sorry, the rules
are not finalized.
Thank you.
Well, Your Honor, the witness has testified regarding the rules that are not finalized that they would reduce the accredited capacity of demand response resources. So I'm simply asking, based off of his understanding, whether or not there's anything in the pending rules or the discussions before MISO that would preclude the development of new demand response resources once those rules are finalized.
Well, he can answer to his understanding as he sits here today.
Well, I think it depends on what you mean by preclude. It's possible that those demand response related rule changes reduce the market value of demand response to the extent that it's not cost effective to do so. So I don't think there's going to be any restriction on the development of it, but that doesn't mean that they might not be developed if the requirements are sufficiently stringent that would reduce the market value.
Okay, thank you. No more questions. Thank you.
All right. I can invite any redirect?
No.
Okay. Thanks very much. You're excused.
Thank you.
We're going to keep going, Your Honor.
Well, who's left from WEPCO?
We've got Dr. Hall, and then I believe if you have a question for Mr. Stazek.
I think I can quickly run the question to to witness Stasek, and then we'll take a quick break. I guess I'm debating. I think if I describe the question, I want to get the answer that I got in the and we can go off the record. I want to get the answer that I got in the 316 case. I think we can probably do that in public because we don't really have to actually say exactly, but can just confirm. So what we did have, we were discussing Exhibit 12 and the I think it was the exhibit that was presented there. We just and we were just I just wanted the witness to verify the units that it indicated in that table as being the ones that are at issue in the case.
Yeah, that's easy enough, Your Honor, and agree we can do that in public session.
Okay.
Without referring to the name of the customer.
Yeah, no, the customer isn't actually at all the point, but the units, I think we just want to make sure, confirm that the units are the ones that are in the case. So yeah, if there's any other questions for Stasek, are we opening this up to a long cross, or is it just we're just covering this issue? Okay, I'm not hearing anybody there, so I'll expect to do this pretty quickly. So yeah, if we can call Stasek, that would be great. We'll just take care of this quick. Yeah, I'll swear you in, and you both are muted. So, okay, there we go. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
Good afternoon, Mr. Stasek.
Good afternoon, Mr. Wilson.
Please state and spell your name.
Richard Stasek, S-T-A-S-I-K.
Did you prepare and cause to be filed direct rebuttal, surrebuttal, and sur rebuttal and accompanying exhibits in this case?
I did.
Do you have any corrections to that testimony today?
No, I do not.
If I answer the questions contained in your testimony, would your answers be the same?
They would.
Mr. Stasek is available for questioning.
Okay, thanks. So witness Stasek, I'm going to refer you to your Exhibit 12, which is confidential. But since we're in public session, we're just going to, I think we can gather the information without disclosing anything that's confidential. So just keep that in mind. I think you probably heard that discussion.
Understood.
All right, great. So I think the easiest way to do this is if you look at Exhibit A of that's attached to your Exhibit 12. It lists generation assets. And let's see. So the first set of assets that's listed in that table, are those the assets that are an issue in this case?
The assets that are an issue at that document are those that are contemplated in this case, as well as in case 6630 CE 316, Your Honor.
Okay. I think that's probably all I need just to confirm that. Great. Okay. So any redirect on that?
No.
All right. Great. Thanks. You're excused.
Thank you.
Oh, wait. I did have one other. No, that's okay. Let me. No, that's right. Yeah. Thanks. You're excused.
Thank you.
All right. So with that, it's just about the right time I wanted to break. So let's get back together here at 1 p.m. and we'll take witness hall. I did want to mention, we can do this off the record. Did Dr. Grant have and I don't think anyone else needed to go should have any conflicts with time. I think we should be able to work through those, except I think Dr. Grant had a need to go earlier today if we're going to take him today.
Yes, we were hoping to have him on the stand before 3, if that's possible.
So I think we can probably after hall we'll take Dr. Grant.
Okay, it should be quick. We're just having him verify testimony in exhibit.
Oh, okay, that's fine. All right,
Brandon, can I just sorry to interject, but we were asked the question about who could testify to the owner to the cost of the OCCT project.
Yes.
I believe that would be Mr. Taruli. I guess I would also say Mr. Stasek and Mr. Taruli testified about the potential of those costs increasing in both of their testimonies. So just want to point that out too in case.
Yeah, I did remember that was the other mention I have for Stasek. Is Taruli available then?
He is available. I don't know how long it would take or if it's incremental to what he's already testified to, but he's available to testify after the break if that works best.
Okay, I think we could probably get everybody in. So hopefully we can get Hall and Taruli and then Grant. Thanks for reminding me about that.
Yep, thank you, Aaron.
Thank you.
All right, so we'll break for now. We'll be back at 1 p.m. Hey, it's 1 p.m. So are we ready to take our next witness?
And one, apologies for not having him in the seat, but he's Mr. Terulli is coming as the next witness. Staff still wants to ask him some questions.
Okay, great.
And I guess
Your Honor,
are we on the record?
No, we're off the record.
Okay.
Yeah.
Certainly. We no longer have those cross-examinations for witness Terulli.
Okay, thank you.
Okay.
So we'll release him, and then we'll go get Dr. Hall. Would be our next witness.
I think there is some question regarding. I did have a follow-up from the questions you were asking, Attorney Bedford, and if Terulli is the appropriate witness, like to present that question to the witness.
Okay, so either way, it's not me. So
yeah, let's bring that. Yeah, no, we're not. You're free.
Your Honor, this is Matt Frank with WLGCC. I have audio connection with the room, but I have to. I'm getting a message that my video has been disabled.
Yeah, I got it. You left it on, and I just turned it off for your privacy. It should be working now. You should get a pop-up. There you go. Yeah.
Okay. All right. Thank you.
Yeah. So, okay, let me switch some names here. So I hope I have the right witness. I realize this probably is not what I planned. So since we have the witness here, we'll ask. But okay. So I did want to just bear with me a second. I wanted to get a data request up. I'm sorry, Attorney Bedford, do you remember the data request that I was talking about to you regarding that? The documentation on the assurances?
I do not off of the top of my head. Let me see if I can come up with it.
I just went back and searched for data request, DG 9.1.
That was the one that I was talking about related to model runs. It's referring to something else, and let me see if I can find it.
If you can give me a couple of keywords, I can search back.
It hasn't come up yet, but thanks.
Oh.
Yeah. Closely related, but it's not going to be.
It was DG 6.01, I believe.
Okay. Yes, I see that. Okay. Okay, and that's the. Oh, so let's get started. So I got that ready to go. Great. All right, so let's get started. We'll swear in the witness. So one of you will have to unmute.
Sorry about that, Your Honor.
No, you're good. Raise your right hand. And do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Go ahead.
Can you please state and spell your name for the record, Mark?
Mark Terulli, MARKTERRULLI.
And for purposes of this proceeding, did you prepare or cause to be prepared rebuttal testimony?
Yes.
And if I were to ask you the questions contained within your testimony today, would your answers be the same?
Yes.
Mr. Truly is available for cross-examination.
Okay. Yeah, so I did have a quick question for you, witness Turley, and I realize now that you were being called to answer a different set of questions that commission staff had, but since I have you here, see if we can try to get you an answer from you. If you're not the appropriate witness, we can move on to somebody else. And it does relate to a data request response to commission staff. That's number DG 6.01. And it was answered by witnesses Stasek and Gerlikowski. So if you don't have an answer, I understand. But since you're here, I just wanted to ask you, there's a passage here. This request relates to issues about the EPC, the engineering, procurement, and construction contract, and that the contractor at this point has assured the company that there will not be cost increases that occur according to this response. And just wondering, to the best of your knowledge, do you know whether there's any documentation provided by the contractor to WEPCO, or is any documentation that WEPCO has that memorializes this assurance?
No, I'm not aware of anything documented. No.
Okay. And okay, so now Stasek and Gerlikowski answered this question, but to what extent would you have knowledge of any documentation that would be coming in about that?
I would generally have been copied on something if it was project specific.
Okay, that's probably good enough. So basically, the answer is there is no documentation, as far as you know.
As far as I know.
Okay, all right, great. That's fine. If WEPCO has a better answer from someone else, feel free to bring that witness back. But I think we'll just go with what we have. All right, so that's all I had. Any redirect? Any other cross, I should ask? And any redirect? Do you want me to show that back up on the screen?
No, we're fine, Your Honor.
Okay, all right.
We don't have any redirect.
Okay, good. Okay, so we can excuse this witness. Thanks very much. And next witness.
Your Honor, Wisconsin Electric calls Dr. Caitlin Hall.
Okay. Hey, Dr. Hall, raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Dr. Hall, did you prepare and submit rebuttal, and sir rebuttal testimony in this proceeding?
I did.
Did you also offer 3 exhibits?
I did.
Is everything stated in your testimony true and accurate to the best of your knowledge?
Yes.
If I were to ask you the same questions today, would your answers be the same?
To the best of my ability, yes.
This witness is available for cross.
Okay, just off the record, since we'll probably have some questions for you, your sound a little low on my end. I don't know if anyone else is. Okay, that sounds like we fixed it. Okay, great. All right, so let's return to witness with cross-examination. Is it HCW UCS has questions?
Yes, Judge Newmark. Good afternoon, Dr. Hall. My name is Grant Snyder, and I represent Healthy Climate Wisconsin and Union of Concerned Scientists. And I just have a few quick questions that I'm hoping you can help me with. So you are an epidemiologist with experience in air pollution emissions modeling and determining whether a generation project complies with the National Ambient Air Quality Standards, correct?
I would like to qualify that a little differently. I am an epidemiologist with experience in measuring exposures in human populations and measuring health outcomes associated with exposures.
Okay, but you are familiar with the NAAQS standards and the protective level that they provide, correct? Okay,
Yes.
thank you. Okay, please turn to page 5 of your surrebuttal testimony at line 7. Judge Newmark, do you want me to give you a second to pull it up?
You can go ahead. That's fine.
Okay.
Page 5.
Yes, page 5, line 7. So you state here that NAAQS, as developed by EPA, are designed to protect the most sensitive populations with an adequate margin of safety. Do you see that?
Yes.
Okay, and can you explain what adequate means in this context as it relates to NAAQS?
Sure. I think the best way to explain it is when the NAAQS standards are set, they're set with a buffer, meaning that if the standards are exceeded, it does not directly correspond to harm to human health. There's usually
does not directly correspond to
harm to human health.
Okay, and is it fair to say that this adequacy standard is not meant to protect against all possible public health risk stemming from fossil generation emissions?
Yes, that would be fair to say. That would be a wide list.
So there would still be some risk, but it would be below the buffer zone that EPA set.
I think what I'm saying here is that the regulations are designed to protect public health with an adequate margin of safety. That means that exceeding that limit would not directly result in harm to public health.
But the standards aren't designed to prevent all risks of public health harm, correct?
It's hard to answer that question because all risk is a very subjective term.
Well, would you expect, based on your epidemiological experience, that a fossil generation facility, which otherwise complies with NAAQS, may still pose some public health risk?
No, if a project is complying with the NAAQS, I would not expect it to pose public health risk.
So your opinion would be that it would eliminate all public health risk.
Again, saying eliminate all public health risk is a very strong word choice and subjective. So I would say that it would regulate with ample margin of safety for public health.
Okay, I just want to clarify because it sounds like I've heard two different things. It sounds like you would not expect for there to be harm, but then you say it's too far to say that there would be no harm. Is that correct?
Maybe restate that, please.
Sure. So I feel like I've heard you say two different things. So one is that if an entity complies with the NAAQS, you would not expect a risk of harm. But then you've also said that that the NAAQS are not designed to protect against all public health harm, correct?
I think when you say all public health harm, that's a little subjective. And maybe if you could define that.
Say that again.
Could you define that?
You wouldn't all public health harm would be that we would not expect to see any public health harm as it would be related to premature mortality or missed work days or something to that effect from a project.
So I would agree with that.
Okay, can you restate your agreement, please?
I'm sorry?
I said, can she restate her agreement, please?
So when you say all public health harm, if you are meaning the outputs of the health impacts from the COBRA model, there's roughly 25 of them. then I would agree that if a project complies with the National Ambient Air Quality Standards, I would not expect to see public health harm for those endpoints.
So you'd expect to see no missed work days, no missed school days, no premature mortality if an entity was otherwise compliant with the NACs.
Correct. But I think I would also like to clarify that the COBRA model, the outputs from that model do not mean that those health impacts will occur if the project were to proceed.
Right, I understand that. I'm asking specifically about what your opinion would be about the risks that a otherwise NACs compliant generation facility would have on public health. And it sounds like, I just want to clarify here, but it sounds like from what you're saying that your expectation is that if an entity was otherwise NACs compliant, those COBRA health endpoints that you brought up, you would not expect to see any of those.
Correct.
Okay, perfect. That's all I have. Thank you.
Okay, other cross? Nobody? Redirect?
No redirect, Your Honor.
Okay, thanks very much. You're excused. Who do we have left for the applicant? Looks like everybody, right?
Nobody.
That's right,
everyone.
Okay. All right, so let's move on. So we were going to take Dr. Green next. So let's call that witness.
Sorry, maybe I misheard. Dr. Grant, Your Honor?
Grant, yes, you're right.
Thank you. The commission calls Dr. Grant to the stand.
So maybe just say something.
Oh, yes, I'm here.
My screen. Oh, there we go. Great.
Sorry.
That's okay.
Thank you.
And I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Daniel Grant.
And what is your position at the Public Service Commission of Wisconsin?
I'm a public service engineer.
And did you file or cause to be filed direct testimony and rebuttal testimony in this docket?
Yes, I did.
Did you also cause to be filed one exhibit and did you also cause to be filed one exhibit in this docket?
Yes, I did.
And are you also sponsoring any staff special exhibits?
Yes, I will be sponsoring the data request response exhibit and the completeness determination exhibit today.
Thank you. And are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony or to those exhibits at this time?
Accepting the discussion from earlier about the footnotes correction, no.
Thank you. Your Honor, the witness is available for cross-examination.
Hey, do we have any questions? No one? All right, thanks. You're excused.
Thank you.
All right, so we'll move on to our next party, which in our alphabetical list would be AEU.
Yes, thank you, Your Honor. I think I see my witness on screen as well.
Okay.
Hello.
Yes, there you are. Thanks. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Your Honor, before I conduct my direct examination, can we go off the record for a brief minute?
That's fine. Go ahead.
Your Honor, I intend to ask my witness to attest to the testimony, but also ask her very brief questions in response to some of the rebuttal testimony that was filed in relation to her testimony. And so before I did so, I just wanted to let you know and let the parties know that I intended to do that.
Oh, yes, that's expected practice. So you can proceed without any further notice on that. The one thing I would mention, though, I don't know if I have those exhibit numbers, the additional ones, and you know the numbers themselves are wrong. I don't know how many exhibits you need. If you just want to kind of gloss that over, it's okay. Just put it like that, I guess. So, I mean, we could say potentially more exhibits, or I guess just stick with what's filed. Maybe just have her verify what's filed. The rest we'll just deal with later. Okay. Just didn't want to catch up there. Okay, let's get back on the record.
Thank you, Your Honor. Good morning or good afternoon, Ms. McCune.
Good afternoon.
Can you please state your name and spell it for the record?
Miriam McCune. First name, M like Mary, I-R-I-A-M like Mary. Last name, McCune, M like Mary, A-K-H-Y-O-U-N like Nancy.
Thank you, Ms. McCune. And could you please state the name of the party that you represent in this proceeding?
Advanced Energy United.
Ms. McCune, did you prepare and cause to be filed direct testimony and 3 accompanying exhibits in this case?
Yes.
Did you prepare and cause to be filed rebuttal testimony in this case?
Yes.
Did you prepare and cause to be filed surrebuttal testimony in this case?
Yes.
And was each of those testimonies and exhibits true and correct as of the time it was written to the best of your knowledge?
Yes.
Ms. McCune, upon your review of your pre-filed testimony prior to this evidentiary hearing, did you identify any corrections that you would like to make to that testimony?
Yes. At footnote 1 on page 6 in my direct testimony, I erroneously state that the Wisconsin wind speed is 7.75 miles per hour and 100 meters at 100 meters above sea level, or I should have stated the Wisconsin wind speed is 7.75 meters per second at 100 meters above surface level.
Thank you, Ms. McCune. Would that correction, if asked the same questions today as asked in your pre-filed testimony, would your answers to those questions be the same?
Yes.
Ms. McCune, in his rebuttal testimony, WEPCO witness Mr. Haggerty clarifies what he calls the main point of his rebuttal testimony, which is that instead of relying on more recent MISO DLOL values, you chose to rely on older DLOL values that, according to Mr. Haggerty, significantly favor BESS or battery energy storage systems over the OCCT project. How do you respond to that criticism?
Just to be clear, the source I used for the direct loss of load DLOL values, which MISO is rolling out in the 2028-2029 planning period, the 2024 MISO Regional Resource Assessment was what I used. It was published on November 6, 2024, just 16 days before the planning year 2025-2026 document Mr. Haggerty uses was published. And the reason I use that source is because it has DLOL values for 2030, which is, looking outward and, for a system that's going to be installed and operating in 2027, these later values are most useful. And that does use some modeling from 2023 just for the framework, but even the resource that was used by Mr. Haggerty and Mr. Gerlikowski was also using an older white paper from March 2024. At this point, the MISO has not yet issued those DLOL values for 2030, and they're only indicative for 2025, 2026, or 2027. And I'd also note that since MISO's proposed resource accreditation method is based on measuring a resource's expected contribution to reliability using expected class level performance and historical resource level performance, more renewable energy and transmission build-out on the MISO grid will result in BESS being able to charge more frequently with low-cost renewable energy, making it more available as the grid conditions change. And this seems to be something MISO has noticed when it has increased the capacity accredited to BESS in 2030 in its 2030 values in the report I cited, and decreased the capacity value it assigns to natural gas facilities. Finally, I'd note the same planning year 2025-2026 loss of load expectation study report that was the basis of Witness Haggerty's Exhibit 16 table 3-1 on pages 21 and 22. It shows that the equivalent forced outage rate for thermal units has increased measurably for thermal units such as CTs over time. And on page 7 of that report, it says MISO's adjusted and planned forced outage rates for thermal units due to historical data showing increased outages under extreme cold temperatures. To me, that suggests that while the future is bright for BESS, it is getting dimmer for thermal units.
Thank you, Ms. McCune. With that, Your Honor, I tender the witness for cross-examination.
All right, we have the applicant on the list for questions.
Yes, Your Honor, applicant has some questions for Ms. McCune.
Okay, go ahead.
Thank you. Good afternoon, Ms. McCune. I'm attorney Patrick Proctor Brown. I represent Wisconsin Electric. I don't think we've met before, is that right?
Nice to meet you.
Nice to meet you too. So I just want to ask 2 follow-up questions on what you just testified about. Is it your position that Wisconsin Electric should replace the OCCT project with 1,100 megawatts of BESS?
My position that Wisconsin Electric should go back to the drawing board with its Plexos modeling and re-examine elements that I've pointed to in my direct testimony to find the best outcome, because I, as I've stated in my direct testimony, believe that the modeling inputs are biased themselves.
Yeah, so I didn't ask you about other testimony. I asked you a very specific question. Is it your position that Wisconsin Electric should replace the OCCT project with 1,100 megawatts of BESS?
I have not analyzed that using Plexos myself or any other capacity expansion planning or production cost modeling. So I would need to analyze that question myself. I can tell you the inputs for the cost of BESS are too high.
Yeah, so again, that's not my question, respectfully. It's a pretty simple question. Is it your position that Wisconsin Electric should replace the OCCT project with 1,100 megawatts of BESS?
Your Honor,
I would
I'll
need
object
resources.
I'll object to that question because the witness has now asked and answered the question twice, providing some context on her position. So at this point,
she hasn't answered it, Your Honor. She's talked about other things, but it's a yes or no question. And I just would like an answer to my question rather than kind of a combative, overly broad answer.
Respectfully, Your Honor, that's not a yes or no question. The witness is offering context on her position. She's being asked about her position.
Okay,
it is a yes or no question.
I think what our normal practice should be, and it usually doesn't end up being this way, we do allow witnesses to expand on answers. But I think technically the process is that if a witness should be answering the question directly, and then if the witness, in terms of providing more context or in terms of clarifying a question, that can be done on redirect. So if we can have an answer to this question and move on, and then to the extent that that answer needs to be clarified, the AEU can do that on redirect. But you know, just everyone realizes that the bulk of testimony is in the pre-hearing written testimony that's been filed here. Unless someone's going to be changing their position on the stand, that testimony is still in the record and is probative. So so what I'm saying is you don't necessarily need to equivocate and provide the context and the background.
Yes or no. I can do a yes or no.
Yeah.
I will do it.
I'm just trying
Thank
to
you.
instruct everyone, but thanks. Okay,
Sure,
so
sure.
let's move on and have an
Okay.
answer to that question, and then we can proceed from there. Thanks.
My position is no, not necessarily. My recommendation in direct testimony is to look at the hoteling alternative plan, which includes a DLOL effective capacity of 1,160 megawatts in 2027, and it includes 237 megawatts from the project, 55 megawatts of ICAP from the Paris RICE, 800 megawatts of solar, 300 megawatts of wind, 780 megawatts of batteries, 7 megawatts of EE, and 171 megawatts of DR.
Okay, thank you. Is it your position that 1,100 megawatts of BESS would be cheaper than the OCCT project?
No, not on an overnight capital cost basis. Depending on how it's charged, it could definitely be cheaper on a levelized cost of energy basis. Yes.
Thank you. Ms. McCune, I want to move on to some questions that are related to Mr. Arndt's rebuttal testimony. Your Honor, if you don't mind pulling up page 11 of Mr. Arndt's rebuttal testimony, that'd be great.
Happy to do that. Just give me a second.
I need a moment.
Let's go off the record for now. Rebuttal in public, I'm guessing. And
yes,
what page are we looking for?
Page 11, please, Your Honor.
I'm there.
Thank you. Ms. McCune, you
No,
read
we're
Mr.
off the record.
Oh.
Am I in the right place?
Can't see the page number, Your Honor. I'm sorry.
Oh, yeah, sure. It's P11.
Yes, that's correct.
Okay, and all right. So what's top of the page, or
If you don't mind capturing the question at the top of the page, that'd be great.
oh, okay.
So I guess 10 would have been the right direction. Sorry about that.
Let's see a question there. Is your version different?
I might have been looking at a different version, but these are just general questions, so I don't need to have anything specific up.
Okay. All right. Well, we'll try, see what happens. All right. So let's get it back on the record. Go ahead.
Thank you, Your Honor. Ms. McCune, have you read Mr. Arndt's rebuttal testimony?
Yes.
And then kind of beginning on this page and continuing for a few pages on through page 16, Mr. Arndt is discussing reliability concerns expressed by the North American Electric Reliability Corporation, NERC, Reliability First, and MISO. Would you agree with that general summary of his testimony here?
I would need a moment to read all of it and refresh myself. You're asking me about very specific pages, and I just now turned to them. So I apologize, but I cannot answer that question.
Well, we can go off the record and just give you a minute to review that. Looks like we'll have some follow-up questions for that. So
thank you, Your Honor.
Your Honor, I just have a question for counsel. Counsel, could you just
we're off the record.
let me know what pages we're looking at?
My apologies. So it would be starting at 13 and going to about page 17. And the question right there is what I'm after. Have NERC or reliability first.
Okay, thank you.
So I think Attorney Proctor Brown, I think we might have moved your microphone a little to capture the witness speaking, and now you probably want to move it back.
Thank you, Your Honor.
Yeah, okay. So just let us know when you're ready.
I think that's directed to Ms. McCune, right, Your Honor? So
yes.
I agree that
No, wait,
we're not. No.
Let's get back on the record. So the witness has reviewed the testimony? Are you prepared to answer?
Yes, I am prepared to answer.
Go ahead.
Thank you. So, Ms. McCune, before we went off the record, my question was is this part of Mr. Arndt's testimony generally discussing reliability concerns expressed by the North American Electric Reliability Corporation, NERC, Reliability First, and MISO?
And just give those page numbers again for the record.
It would be, I believe, 13 through 17.
Thanks.
Yes, they are.
What is NERC to your understanding?
That's the North American, it's the Electric Reliability Corporation. I don't remember the exact acronym, but I'm very familiar with what NERC does.
So if I told you NERC stands for North American Electric Reliability Corporation, would that comport with your understanding?
Yes.
And if I told you they're the Electric Reliability Organization authorized by FERC, is that your understanding as well?
Yes.
They're in fact a not-for-profit international regulatory authority whose mission is to assure the effective and efficient reduction of risks to the reliability and security of the grid, right?
Right.
Would you agree NERC is a credible source on the issue of grid reliability?
Yes.
Sorry, was your answer yes?
It's kind of cutting off.
Yeah.
Can you say that again, Ms. McCune?
Yes.
Thank you.
Possibly to hold your mic up to your mouth. I think, is it hanging? Oh, no, it's not hanging on the cord.
What is reliability first to your understanding?
It means managing for the quality of power on the electric grid.
So actually that's not quite right. Reliability First is the regional organization for reliability and security of the electric grid under delegated authority from NERC. Would you agree with that?
I am not familiar with all of NERC's tenants, so I'm unable to answer the question.
Okay, so you're just not aware of what the regional reliability organization that covers Wisconsin is? Is that an accurate statement of your knowledge on the topic?
That is not an accurate encapsulation, no.
Okay, who is the reliability organization delegated by NERC for Wisconsin?
I don't know. Who are they?
I told you it's Reliability First, and you disagreed with me. So
I don't think I disagreed with you there, but keep going. I think we can have a better discussion than this.
Okay. Would you agree that Reliability First, as the regional reliability organization, is a credible source of information for reliability?
I'm not familiar with the sub-organization to which you refer. I'm familiar with NERC, but not Reliability First.
Okay. But you have no reason to question the credibility of Reliability First, right?
I have no reason to question it at this time since I'm not familiar with it.
Okay. Do you consider MISO to be a credible source on issues of grid reliability?
Yes.
Without going through these 5 pages in detail, do you have any basis to dispute Mr. Arndt's description of NERC's and Reliability First's concerns about reliability in MISO?
No.
Your Honor, if you could scroll back up to page 13, please. Do you have any reason to question or dispute NERC's views on the importance of natural gas generators for reliability?
No.
Switching topics, I want to talk a little bit about energy efficiency and demand response. Is that okay with you?
Yes.
Is it your position that energy efficiency and demand response are potential alternatives to the 1100 megawatt OCCT project?
Alternatives in full?
Yes.
No.
Would you agree that Wisconsin's statewide focus on energy program has been effective?
Effective at what?
At achieving its goals of achieving energy efficiency for the state of Wisconsin?
For the goals set forth, yes. There are some utilities doing more than WEPCO, but yes.
WEPCO as a utility is the biggest contributor to focus on energy. Isn't that true?
In terms of, yes, the amount that has to be paid into it, yes, legally, yes.
Thank you. The effectiveness of any energy efficiency program, including the focus on energy program, ultimately relies on the actions of consumers, correct?
Yes, which is why agreements need to be made. Yes.
Energy consumers need to take action and participate in any energy efficiency program, correct?
As agreed, between the utility and the consumer, yes.
The utility cannot mandate participation in an energy efficiency program, correct?
It can only mandate it in so much as agreed in the agreement between the utility and the customer, yes.
The utility has to rely on consumers to take action outside the utility's control?
Yes, to the point of agreement between the two parties, yes.
The same is true of the commission, correct?
What is true?
Just a vagueness objection. I'm not sure what the council is referring to. The same.
Fine, I'll withdraw. That's fine. I'll withdraw. The commission can't mandate that consumers participate in energy efficiency programs, correct?
Correct.
You would agree that consumers also have to take action for demand response programs to work, correct?
Okay, off the record. So we're having trouble hearing you again. No, no, very.
It seems to cut out the very first thing you say, unfortunately.
Is this better?
Yes, so far. We'll just keep trying. Okay, so we have a question, an answer I think we didn't catch. Is that correct, Debbie?
Well, I could see her lips and she said yes.
Okay, as long as you as long as you say she said it, then that's good enough for me. All right, let's proceed on the record.
Okay. Consumers need to opt in to a demand response program in sufficient numbers for the demand response program to be effective, correct?
I saw lips again, but I didn't hear anything. Can you say it again?
Oh, correct.
Thank you.
Thank you. The utility cannot mandate participation in a demand response program, correct?
Correct.
The commission cannot order consumers to participate in a demand response program, correct?
Correct.
And just like energy efficiency, the utility has to rely on consumers to take action outside the utility's control, correct?
Correct.
Thank you, Ms. McCune. That's all I had.
Okay. Any other cross for this witness? Okay, redirect.
No redirect, Your Honor. Thank you.
Okay, I just wanted. Oh, did we lose her? There she is.
No, I just was leaving.
Okay, I just wanted to ask. I got to excuse you first. So I just want to ask you one question for clarity. Are you're not a lawyer trained as an attorney? Is that correct?
I am not.
Okay. All right. So thanks. Any follow-up from that? All right. And that's it then. You're excused. Now you can go. That was great. All right. Let's move on. So we have a used witness, and who do we have next? Cub is next.
Yes, thank you, Your Honor. Cub calls Mr. Burgess to the stand.
There we go. All right, let me adjust the pins here. Burgess. I see you there. Okay. Okay. Raise your right hand, witness Burgess. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
Yes, I do.
All right. Thanks. Go ahead.
Good afternoon, Mr. Burgess. Can you state and spell your name for the record?
My name is Edward Burgess, Edward Burgess.
Did you prepare and cause to be filed direct, rebuttal, surrebuttal, and originally 38 accompanying exhibits?
Yes, I did.
Okay. And if asked the same questions set forth in your testimony here today under oath, would your answers be the same?
Yes, they would.
Accepting the corrections directed by the judge here in this proceeding earlier today, is your testimony and your exhibits true and correct to the best of your knowledge?
Yes.
Do you have any corrections to add to your testimony or exhibits today?
Not at this time.
Okay. If I could turn your attention to Mr. Gerlikowski's surrebuttal. On page 4 of his surrebuttal, he responds to your earlier testimony relating to a model run that's been referred to as the quote 6.9 end quote run. And he has some critiques of your testimony. Do you have a response to that today?
Yes, I do. Should I provide that response now?
Yes, please.
Okay. Yeah. So I wanted to just clarify, the discussion around this model run 6.9. And I guess to preface that, I want to remind the commission that, there was no model run performed to date that has the most up-to-date refined forecasts for new load customers from last fall. However, there were two primary model runs that Wisconsin Electric conducted in February of this year with a 450 megawatt load forecast. That was in response to staff's request. And I've referred to those as model runs 6.3 and 6.9, and there's variations of these 6.4 and 6.10. So model run 6.3 selected only 3 OCCT units and significant amounts of incremental solar, whereas model run 6.9 selected 5 OCCT units and no incremental solar. While Wisconsin Electric didn't provide the input assumptions to CUB in the same format that they did for the initial model runs, so I wasn't able to review all of the model run details in preparing my testimony. So while I only had limited information on those inputs, I did observe the following regarding the model outputs, and that is that over the 30-year analysis period from 2023 to 2052, model run 6.9 added 0 megawatts of incremental solar, the only exception being the already planned High Noon project. So, I expected that the change to solar's capacity accreditation using the MISO's new DLLOL methodology might have reduced the amount of incremental solar being added. I did not expect it to be reduced to 0 for all years. So not only is this a surprising result that there was no solar added over 30 years, model run 6.9 and variants thereof were essentially the only run where that was the case. Even model run 6.7, which included the new DLOL method, included over 2,000 megawatts of new solar additions. So as I was preparing my testimony, my best guess with the limited information I had was that there was some other change to the solar inputs of the model run versus the others. If I'd had the chance to review the input files, I might have agreed with the PSC staff statement that, the solar inputs were not changed. However, even if that were true, the fact remains that 0 megawatts of solar was added over 30 years. This is still an unexpected and counterintuitive result. For example, if hypothetically the DLOL adjustment had reduced the capacity credit of solar to 0%, I'd still expect some amount of solar greater than 0 megawatts to be added from now through 2052. Solar has energy value. It's relatively cost effective as an energy resource, so some amount would almost certainly be added at some point over the next 30 years, regardless of that capacity credit. So, I still have concerns that some aspects of the company's modeling was not properly calibrated in that run 6.9. The company hasn't really explained how this counterintuitive result could have arisen. While run 6.9 included some helpful changes, it still included several assumptions that concern me, including the constraint that forces CT additions into a narrow window from 2027 to 2029. Cost assumptions for battery storage, which I maintain are still too high, and the cost and performance assumptions for energy efficiency, which I think undervalue that resource potential. So I just wanted to clarify that, how I arrived at, the conclusions in my testimony, and also the concerns I continue to have about model run 6.9.
Okay, thank you. The witness is available for cross.
Okay, looks like the applicant had questions. We'll start with them.
Thank you, Your Honor. Good morning, good afternoon, rather, Mr. Burgess. James Goldsmith here with Quarles for the applicant. Nice to see you again.
Nice to see you.
Why don't we start on the topic you just mentioned, the model run 6.9, and if we could please pull up Mr. Burgess's rebuttal testimony beginning at page 9.
And trigger finger is getting tired here. Right.
And beginning around line 11, you note that unlike several other modeling runs, model run 6.9, or as the parties sometimes refer to it, 6.09, resulted in 0 incremental new solar between 27 and 29, right?
Yeah, those years, as well as every other year that was modeled through 2052.
And those are the counterintuitive results that you referred to just a moment ago, correct? In your words?
Correct.
Now, just to be clear, it's not actually 0 incremental new solar because it does select high noon, correct?
Right. My understanding is that high noon is an already planned solar project that was, specified in the model versus, generic solar resources that could be selected by the model as incremental resources based on the model's optimization routine.
And do you know the nameplate capacity of the high noon facility?
Off the top of my head, I don't know.
Okay, subject to check, does 300 megawatts sound about right?
300 megawatt of nameplate?
Yes.
Subject to check, that sounds reasonable to me.
Do you know the overall penetration of utility scale solar in Wisconsin in megawatts?
Not off the top of my head, no.
Okay, subject to check, does something like 1,300 to 1,500 megawatts sound like the right ballpark?
Subject to check, I don't have any reason to challenge that.
And this model run 6.9 assumes only 450 megawatts of new load, correct?
That's my understanding, yeah. Although maybe, sorry, 450 megawatts of new load customer additions. There may be some other existing customer load growth that's in there too.
So with 1,300 to 1,500 megawatts of solar already here in Wisconsin, and 300 more modeled with high noon, for a total of 1,600 to 1,900 megawatts of solar, is it really so improbable that an additional load of 450 megawatts would not trigger the need for more solar in the modeling?
I think it's not, it doesn't really seem realistic that no solar would be added over 30 years. You know, like I said, I mean, we're not talking now about just the capacity value of solar, but the energy value. It's a very cost-effective resource from a sort of dollars per megawatt hour standpoint. And to say that no solar will be added over the next 30 years doesn't sort of match my understanding of how the market is evolving. And so I think that there is some question there about whether this is a properly calibrated model run.
And that's based on what I think you said to Mr. Singletary was your best guess of what this model would show, right?
Yes, I mean, that's my best guess initially would have been, you know, there might be something different with the solar assumptions. It could be other assumptions in the model that are leading to this result. But I think, you know, what I'm sort of saying here is it doesn't really pass the smell test to say that there'd be no solar added over the next 30 years.
And at line 18 of page 9 of your rebuttal testimony, you take the position that the most plausible explanation for this is that model run 6.9 included assumed limitations on 2027 to 2029 solar additions that were not present in the other model runs. Do I have that right?
Yeah, that was my best guess at the time. And as I mentioned, I didn't have all the information available to me to assess what those assumptions were.
Okay. Do you stand by that statement?
You know, I think I would probably revise that statement, you know, based on my review of Dr. Grant's testimony, who was able to review those model inputs. He concluded that there was no changes made. So I take that at face value, even though I've not reviewed the inputs myself. But what I still stand by is that there's some other aspect of the model run that is not properly calibrated. It may not be the solar assumptions. It may be something else that's leading to that result.
Well, Dr. Grant didn't just refer to the solar inputs, did he?
I don't recall off the top of my head what.
Why don't we pull up Dr. Grant's cerebral testimony at page 4? And beginning at line 4 of page 4, Dr. Grant says, staff reviewed the inputs and did not find any evidence that the Plexos inputs had been altered by the applicant. Do you see that?
Mm-hmm.
And words, please.
Yes, I see that.
Thank you.
Do you accept Dr. Grant's representation on that point?
Yeah, two things I would say in response. One is it's not clear to me if he was referring to just solar Plexos inputs or, you know, all Plexos inputs. I think second, I think this may go beyond, whether or not there was some difference in this particular model run and whether or not, the modeling as a whole was properly calibrated. It's possible that we're seeing this effect due to other model assumptions, and I mentioned a few of those, including in particular the fact that the thermal resources were sort of forced into this narrow period of 2027 to 2029. That could displace things like solar, especially when they have the ability to take advantage of federal tax credits. So I think there's different things at play here that I think may be leading to a model result that isn't reflective of reality.
So just to make sure I have this portion of your testimony correct, your assertion or accusation really is that the company manipulated the model to select against solar, and that even though staff looked for that and didn't find it, you still think it must have happened?
I don't know whether this was manipulated intentionally or not, but there is something happening here that, again, like I said, doesn't appear to be calibrated correctly, and so I remain, somewhat skeptical that this model run is accurate.
Well, on page 9 of your rebuttal testimony, you said the most plausible explanation is that this model run included assumed limitations on solar additions. That's intentional manipulation, is it not?
Yeah, I think when you look at the model results and see that one model run out of dozens and dozens has no solar and all the rest do, I mean, the most reasonable kind of explanation for that is that there's something going on with the solar itself. Now, again, I haven't had the opportunity to review those inputs like staff has. So, if I had reviewed those inputs, I might have come to a different conclusion. But I don't think it's unreasonable to suspect that's what's driving this result initially. Some further investigation might suggest that there's other factors leading to this result, but the bottom line is the result is still, out of step with all of the other modeling results that the company's presented, and I think just a sort of reasonable assessment of whether or not there will be solar in the future. Yeah.
And again, that's based on your best guess of what this model run should show.
It's based on my assessment of all the analysis that's been done, in this proceeding and, others that I participated in, and sort of my general understanding of how these models work and how resource planning works.
And again, you don't have access to the Plexus inputs that you're accusing the company of manipulating, correct?
Oh, no, you're going to have to rephrase that if I'm going to allow it at all.
Your Honor, I asked him about these lines on the bottom of page 9 of his testimony, and he agreed that they referred to intentional manipulation of the inputs.
I'm sorry, I apologize. I think I have a poor connection here. I missed a portion of your question. Could you restate it?
I'm happy to, Your Honor, to address your concern by confirming with the witness that that was his accusation, if we'd like to start there.
I think we've been over this already, though. I mean, if he answered that already, why are you asking it again?
Previously, I asked him to confirm that that was his accusation. He said it was. Now I asked him to confirm that he did not have access to the inputs that he accused the company of manipulating, and you indicated you would not allow that question, which is why I was going to go back and reconfirm the previous point.
Okay. No, I can allow that. Go ahead. If you heard the question, go ahead and answer.
Sorry, my connection seems to be a little bit shaky here. So could you restate the question?
Yes, my question is simply asking you to confirm that you do not have access to the Plexus inputs that you have accused the company of manipulating, correct?
I guess I would just, I never used.
I remember him saying it may or may not be intentional. That's the answer I remember him saying. He wasn't accusing manipulation. He's saying he wasn't understanding what happened with the inputs, and he did not say that they were intentionally manipulated.
All right, Mr. Burgess, does that adequately capture your testimony on page 9 of your rebuttal? May or may not have been manipulated?
Yeah, I think the may or may not have been manipulated, and regardless of whether it was manipulated for that particular scenario or not, then the results still speak for themselves.
And I understand that was your position when you filed your rebuttal testimony. You've now seen Dr. Grant's latest testimony on this point, which we reviewed together. My question for you now is, do you still believe that the company manipulated model run 6.9?
No, that's not what he's saying. We haven't established that the company manipulated or that he believes the company manipulated the model runs, the inputs.
I can rephrase it, Your Honor. I'm not trying to be tricky here. Mr.
Okay,
Burgess.
but I think we've been through these questions many times. I think we got sufficient answers. And the recap questions just seem to be getting you in trouble. So
I would just like to confirm whether his view has changed since he filed his rebuttal testimony.
and he answered that. He said, given Dr. Grant's testimony, he would change that testimony in rebuttal. So then you went on with the other follow-up questions, and we have a record on that.
All right. Why don't we move on?
Okay, thanks.
Mr. Burgess, you didn't do any of your own Plexus modeling in this case, correct?
No, I didn't.
And in the Paris-Rice docket, you confirmed that you have never used Plexus yourself, have never been employed by a large public utility, have never done in-house resource planning for a public utility, and have never participated in commodities trading, correct?
That's right. I have done modeling using tools similar to Plexus for capacity expansion and production cost modeling, and developed resource plans of utilities, although I've never been employed by a utility, and I'm not a commodities trader, correct?
And you're not a lawyer, correct?
Correct.
Is it your position that the company should never be authorized to build a new generation until the commission approves a tariff or service agreement for that new generation?
I think that's partly a policy question, but I think it's, I think there's sorry, could you repeat the question again?
Let's read it back.
Question, is it your position that the company should never be authorized to build a new generation until the commission approves a tariff or a service agreement for that new generation?
I think that I'm not sure if I have a position on that matter. I do think that in general, utilities do have some freedom or flexibility to choose investment decisions that they make, although they may not be guaranteed, cost recovery of those investments if it were deemed to be imprudent. I do think that we're also in a sort of new era of large load customer additions, where I think some sort of additional examination of these types of generation proposals is warranted, because it's outside of the sort of normal practice that we've been accustomed to over recent decades. So I'm not sure if I have a clear answer to that question, but I think there's some element of both.
What I'm really trying to get at with the question is just, a tariff or a service agreement in your framing, as I understand it, is a proxy for some certainty that there's a customer standing behind the load. Is that fair?
Yeah, I think that's a fair assessment.
Yeah. And so my question to you is essentially, is it your position that the company shouldn't be allowed to build new generation resources without that level of certainty about load?
Well, I think that there could be cases where that is permissible, but it comes with risks, and I think that's what the commission has to assess. If that generation is built and there's no sort of guarantee, either through tariff structure or existing service agreement, where are the costs of that investment going to fall? We would hope that new load shows up and would carry those costs, but there's some risk involved without those agreements in place. And then I think it's a matter of, do those costs fall to existing customers, or is that borne by the utility? And so I think that's the balance that we're trying to strike here, is how do we make sure that those existing customers are not put at undue risk for some generation addition that is not there's no firm guarantee that that load will show up, or at least have some sort of commitment to paying for those costs.
Using the term guarantee from your answer just now, and not being a lawyer, do you know whether that sort of guarantee has ever been a requirement of a CPCN in Wisconsin?
I don't know.
Did you ask anyone at CUB about that?
Sorry, it cut out for a second there. Did I ask anybody at?
Did you ask anyone at CUB about that?
I don't know that I did specifically.
As a witness in this proceeding offering recommendations to the commission, do you think it's important to know whether the commission could actually act on your recommendations?
I mean, they're just recommendations. Whether or not the commission can legally act on them is, that's, not, I think what I'm here to provide. I think there could be, certain best practices that, we can discuss, and that's what I'm trying to offer.
And you're not asking the commission to apply a new or different legal standard to this project than it does for other projects, are you?
Not necessarily. Again, though, I mean, we're, sort of in this new low growth era, so some sort of pre-existing, policies, maybe they need to be revisited. I don't know.
Okay, let's turn to your direct testimony, if we could, Your Honor. And we're going to be looking at page 39.
You said direct.
Yes, please, Your Honor. All right, Mr. Burgess, here on page 39 of your direct testimony, you're talking about limitations on wind capacity in Wisconsin Electric's modeling. Do you see that?
Top, you mean, for example, assumed 800 megawatt wind limit? Is that what you're referring to?
Yes, sir.
Okay. Yes, I see that.
And then at line 5, you indicate that, in your view, this indicates that the model would have selected more wind resources as part of the least cost solution, but for this assumed limitation. Do you see that?
Yes.
Now, you don't deny that wind projects face delays due to setback rules, right?
I think in some cases that has been true, yeah.
And you would agree that Wisconsin Electric can't bypass setback rules, right?
I wouldn't assume so.
You don't deny that wind projects face delays due to local opposition, correct?
Some might.
You don't deny that wind is an intermittent resource dependent on how much actual wind there is, correct?
Wind is a variable resource, and it does, depend on how much wind there is. And yeah.
In using the term variable there, do you mean something other than intermittent?
I think in my experience, variable has been sort of the preferred nomenclature, but yeah, I think they're intermittent sort of is a similar term, but it's not my preferred term.
All right. Are you aware that MISO is a, quote, high risk, end quote, area for intermittent energy availability?
Did you expand upon that? I'm not sure what you mean by high risk.
Is this something on the record you can point to, maybe to further his understanding?
Sure. I guess if I could, Your Honor, I would just ask the witness if he knows what MISO means by high risk.
Okay.
I mean, high risk could mean a lot of different things. It's hard to know without a little more context.
Could we pull up Mr. Arendt's direct testimony at page 15, please, Your Honor?
Sure.
I'm sorry, Your Honor, rebuttal.
That's fine.
All right. So there at line 20 of Mr. Arendt's rebuttal testimony, page 15, there's a reference to NERC's conclusion that MISO is at a high risk of experiencing electric supply shortfalls beginning in summer 2025. Do you see that?
Yes.
And are you generally aware of that conclusion from NERC about MISO?
I believe this is taken from a NERC report, the long-term resource adequacy assessment report. Is that correct?
Yes, if you'll accept my representation, yes.
Okay, right. So I think this, and in this report, NERC's describing a high risk of supply shortfalls. I guess I'm not seeing any discussion here about intermittent resources. But you know, yeah, this looks to be like a quote from a MISO or a NERC report. Yeah.
Okay. So that's a fair clarification. Setting aside any qualification relating to intermittent resources, do you deny that MISO has been designated a high risk area by NERC?
In this report, I think that's what they're stating.
Okay, do you know what a wind drought is?
A wind drought, I think, has been referred to as a period of time where there's low wind output that can happen, you know, on rare occasions, and you know, may pose some, you know, challenges in terms of the energy supply from wind energy.
Do you deny that the MISO market has faced wind droughts over multi-day periods?
Yeah, I think the company's witness, Haggerty, talked about this.
So just to clarify, you do not deny it?
Deny that there could be conditions with low wind output?
For multi-day periods in MISO?
Yes, I think this is an issue that, you know, MISO is well aware of and is anticipating and planning for in the future.
You'd agree that severe weather events, storms, natural disasters are growing increasingly severe with climate change?
That's yes, I think there's some evidence that weather patterns are changing due to climate.
And that these events are becoming more frequent, yes?
It could be.
And you don't deny that these weather events could impact the consistent availability of wind generation, do you?
I'm not aware of any specific analysis on the availability of wind generation in MISO due to storms or that type of thing.
Well, in fact, you agree that it is important for system planners to anticipate extended periods of low wind output and plan the system accordingly to handle those conditions, don't you?
Yes, and I believe that is occurring.
We could return to Mr. Burgess's direct testimony, please, Your Honor. Looking now at page 36. Line 4. Oh. Sorry, Your Honor, I appear to have the wrong reference here. Would you mind if we go off the record for just a moment?
Yeah, sure. That's not a problem.
Thank you. All right, found it, Your Honor. We're on bottom of page 37.
Okay, thanks. Go ahead.
We back on?
Yes.
Okay, thank you. Mr. Burgess, at the bottom of page 37 of your direct testimony, beginning at line 19, you state, it appears that WEPCO's approach was to pre-select the company's desired resource option and then use its planning analysis to justify this decision after the fact. Do you see that? You alleged the same thing in the Paris-Rice docket, correct?
I believe so.
And when I asked you in the Paris-Rice docket whether you had any direct evidence that that's what the company did, your answer was, I guess I don't. Do I have that right?
I would, upon further reflection of that exchange, I would probably revise my answer slightly, because I think this, and I'm a little bit trying to be a little bit careful here, because some of what I'm thinking of here relates to some of the confidential material from Mr. Stasic's Exhibit 12. So, which informed my, thinking around this. And basically, there was, my understanding is that there was a decision made at some point to identify the generation resources in this proceeding and in the Paris-Rice proceeding, prior to any analysis being conducted, for this application. And so the sort of timing of those analyses, or lack thereof, led me to, is partly what led me to make this claim here. So I guess maybe, I mean, I'm happy to go into more detail, but I don't want to go into the confidential information here.
Sure, and I don't think we need to. We talked previously about one specific model run, 6.9. This statement that we're looking at now is much broader, and it refers to WEPCO's overall approach to the modeling. And my question to you is, do you have any direct evidence that the company manipulated its overall approach to the modeling to favor a pre-selected resource option?
Well, setting aside any analysis that was done here in this proceeding, what I know is that there was resources identified as part of an agreement with no supporting analysis, for that, and that happened, prior to, well before the application in this case. So, that it's almost, the analysis came later, for this proceeding, and So I think it's just, again, a matter of the timing, the sequence of events there.
Do you have any evidence to support this statement other than the sequence that you just referred to?
I'm not sure I understand the question.
But we're looking together for direct evidence to support the statement in your testimony. The Wisconsin Electric pre-selected its desired resource option and then used its planning analysis to justify this decision after the fact. If we grant that one happened after the other, my question is, do you have any other evidence that that's what the company did?
Right. I guess it seems pretty evident to me that if you're picking resources without any analysis, that, that's what happened. But, I don't know what other evidence that, needs to be presented.
Well, let me make sure I understand your assertion. Is it your assertion that the company, having pre-selected a resource option, actually manipulated the modeling to show that outcome as being the best outcome?
Think. Well, sorry, could you restate the question, or could it be read back?
Let's read it back.
Question, let's make sure I understand your assertion. Is it your assertion that the company, having pre-selected a resource option, actually manipulated the modeling to show that outcome as being the best outcome?
Well, I would say, I think that the company might be motivated to do that. Well, I don't have any direct evidence other than the sort of timing here. I think that there would be some motivation to align the results with what was pre-selected.
Do you think that's the kind of thing that it would be pretty important to be sure of before accusing the company of doing in this case?
I don't know.
Have you undertaken any analysis to determine what would happen to the costs of the proposed project if it is delayed?
No.
If all 5 units of this project are needed by 2030, aren't you just advocating that customers pay more for the same end result?
Sorry, could you read the question back?
Read it back, please.
If all 5 units of this project are needed by 2030, aren't you just advocating that customers may more, I'm missing a word there, may more for the same end result?
Pay more.
Pay more. Let me start again. If all units of this project are needed by 2030, aren't you just advocating that customers pay more for the same end result?
I guess the premise of the question there being that if some units are delayed, that they would cost more. Is that what you're asking?
Well, do you think that's a reasonable premise?
Not necessarily. It may be the case that if some units are deferred, they would be not needed or replaced with other types of resources that cost less. So there's some value in deferral in terms of being able to have more information about an uncertain future, and that could result potentially in lower costs rather than higher costs.
Well, let's stick with the assumption that these units and all 5 of them are needed by 2030. Is it reasonable to assume that in that case, waiting another year or 2 to build them between now and then would increase their cost?
I guess, again, that presumes there would be a cost increase due to a delay. I think that would also have to be balanced against the time value of money and opportunity cost there. But
respectfully, it doesn't actually presume that. I'm asking you if it would be reasonable to assume that.
To assume that the costs would increase due to a delay?
Yes.
I don't know if that's necessarily true. I think it partly depends on the overall supply and demand for these resources, which is constantly changing. So
do you think the cost of combustion turbines is going down in the next 5 years?
No, it may be going up. So I guess from a standpoint of, if there's a delay and if there's an increase in the cost of combustion turbines from one year to the next, then the costs could be increased. I think that, again, that has to be, that's a potential risk that has to be balanced against other benefits, of deferral that I had mentioned previously.
If we could turn now, Your Honor, to Mr. Burgess's rebuttal testimony, please. And page 23, if we could, Your Honor.
Not loading up. Let's go off the record. I'm just gonna close some other windows here. Seatbelt. Okay, so that's correct.
Thank you. Yes, it will be at line 12. Back on?
Yes, yeah.
Okay, thank you. All right, Mr. Burgess, at page 23 of your rebuttal testimony, discussing energy efficiency, you state, beginning at line 12, there will always be a population of customers who do participate, and the collective total of these voluntary customer actions adds up to a meaningful amount of MW megawatt savings that can generally be relied upon. You see that?
Yes.
What is the meaningful amount of megawatt savings that Wisconsin Electric can rely upon in 2027?
You mean from energy efficiency programs?
Yes, sir.
That depends partly on what level of savings are targeted and budgeted for, through either, focus on energy programs or any kind of supplemental activities that Wisconsin Electric pursues or other parties pursue. So there was, I think, in some, so Wisconsin Electric had some assumptions about, one scenario from the Focus on Energy potential study. There were other scenarios that related to other sort of budget levels and incentive levels. And so all of those, I think, could be reasonable amounts of megawatt savings that could be generally relied upon. And I don't have the megawatt number off the top of my head for what all those possibilities are.
All right, same question for 2028. Same answer?
Yeah, I mean, I think I did estimate this in my in some of my testimony using information from the Focus on Energy potential studies. So I would just refer back to to that for those numbers.
Do you know how many megawatts of energy efficiency Wisconsin Electric can rely upon in any year of the study period?
Yeah, as I just mentioned, I put those numbers in my testimony.
But those are estimates based on your review of information that you referred to. They're not an expression of certainty that Wisconsin Electric can in fact rely upon that many megawatts of energy efficiency in those years, is it?
There will be potentially some variation, depending on, program implementation and other factors. But I think that, in terms of an order of magnitude, that would be, amounts that I think could be generally relied upon. It's no different than a supply side generation resource that has, outage rates, and there's certain, amounts that can't be fully relied upon, but you generally know that you have some resource available to you, in the future.
Can you point me to where in your testimony it shows the number of megawatts of energy efficiency that Wisconsin Electric can rely on in 2028?
I had a table on page 21 of my surrebuttal. And I should just clarify that this is based on one of the policy scenarios in the Focus on Energy potential study. There are others that show more savings from energy efficiency than this, some that show less. And so the amount that can be relied upon partly depends upon, again, the sort of level of effort applied, either through Focus on Energy or supplemental programs.
So it's your testimony that the number of megawatts of demand reduction in table 1 on page 21 of your surrebuttal testimony are megawatts that Wisconsin Electric can rely on in generation planning for the next 5 years?
If the programs are supported at the same level as assumed in that focus on energy analysis, then yes. And in fact, Wisconsin Electric's modeling assumes some amount of energy efficiency that's half this level in their own planning. So there's some assumption that megawatt savings from energy efficiency will show up in these years. Although, as I noted, that amount was not consistent with what the focus on energy potential studies estimated, because Wisconsin Electric reduced the performance of the programs by 50% without any commensurate reduction in cost of those programs. So the numbers I'm presenting here are sort of without that arbitrary 50% reduction, and simply stating what was in the focus on energy potential study scenario that Wisconsin Electric had selected.
Now, you're not testifying that Wisconsin Electric in its generation planning for the next 5 years could rely on energy efficiency reductions greater than those shown in Table 1, are you?
Well, reductions greater than this would be potentially achievable and cost effective. As I mentioned, the potential study showed that there was a lot more cost effective energy efficiency beyond the scenario that Wisconsin Electric selected. But, this is what, sort of, I think the expected amount would be under that scenario that the company selected.
And when you say potentially achievable, you don't mean potentially achievable to the degree that would allow Wisconsin Electric to rely on those greater numbers for purposes of generation planning for the next 5 years, do you?
I think we've seen in many places that energy efficiency programs can be scaled up, to up or down based on sort of the level of effort and the budget applied to them. So I think that there's some amount that could be reasonably relied upon. Now we can sort of quibble about the exact megawatt number, but I don't think it's correct to say that you can't rely upon any amount of energy efficiency.
So that's a yes, there is a greater number of megawatts that could be reasonably relied upon?
Than what's shown in this table?
Yes.
If the appropriate, level of effort, funding support were applied, then I think more could be achieved, yeah.
Okay, what is that number, say, for 2027?
What number?
How many megawatts?
I don't know off the top of my head. I'd have to go back to the potential study.
So if the potential study is the basis for that position, is it ultimately your position that in its generation planning for the next 5 years, Wisconsin Electric should be reasonably relying on achieving the full degree of energy efficiency noted in that study?
It would be in customers' best interests for Wisconsin Electric to pursue all cost-effective energy efficiency which would be greater than what is portrayed in this table here.
And of course, that ultimately depends on the level of funding for these programs set by the legislature, correct?
Yeah, to the degree it's in, I think limited or not by the legislature, that's right. Or, perhaps there's supplemental efforts that could be done outside of Focus on Energy as was being discussed earlier.
So to the degree that the legislature does not agree to fund energy efficiency measures at that level.
I'm sorry, can you start that question again?
So to the degree that the legislature does not authorize funding for energy efficiency programs at that level, it would not be reasonable for Wisconsin Electric to rely on that degree of energy efficiency demand reduction in its 5-year planning, correct?
Yes, but that presupposes that Wisconsin Electric has no say at the legislature about these matters. I would hope that they'd be advocating to, remove those restrictions.
At page 33 of your rebuttal testimony, line 1, you state that one possible solution would be to rely upon short-term market interactions with MISO, correct?
Correct.
But in the immediately following sentence, you acknowledge this does present some level of risk, correct?
Yes, and to be clear, I'm not advocating for this as some type of permanent solution, but I think it's, there's always short-term, market interactions that are an option in these in situations like these.
So here you say those short-term market interactions are one possible solution. And then on page 24 of your rebuttal testimony, line 11, you say that Mr. Arendt misunderstood your testimony. Nowhere in my testimony did I argue for the company to rely more on the energy market in lieu of constructing more dispatchable generation. Do you see that?
Yeah, although I would just caution that these may not be referring to the same thing. There's lots of things we can conceive of when we say relying on the market. There's sort of short-term, purchases and, sort of on a daily or hourly basis. There's longer-term power purchase agreements and that type of thing. Tolling agreements.
I'm sorry, what agreements?
Tolling agreements.
Tolling agreements.
So,
well, this is a very broad statement. I mean, it seems to be all encompassing. Nowhere in my testimony did I argue for the company to rely more on the energy market. And then 7 pages later, you state that one solution would be to rely upon short-term market interactions with MISO. So my question is just, which is it?
Well, in the latter pages that you brought up first, I wasn't arguing for that. I was just saying that is one option. Okay, so I think it's mischaracterization to say that that's what I was arguing for. What I'm presenting here is that there's a range. I think I list 5 different options here. So that's one of them. I wasn't suggesting that's the solution that should be relied upon. It's just part of the mix.
I see. So you're identifying it as a possible solution in the abstract, but not one that you're arguing for here.
Right.
Okay. At page 17 of your rebuttal testimony, lines 14 and 15, you state My primary recommendation in this case is for the company to pursue BESS at the existing Oak Creek interconnection site, right?
Right.
So if there's one thing you want to make sure the commission carefully considers, it's this recommendation. Fair?
I think there's a lot of things I would hope the commission consider, but I think one of them is certainly substituting some or all of the proposed CT units for BESS resources at the Oak Creek site. And that's what I'm trying to articulate here, that those BESS resources would have the same advantage as the CTs of, not requiring the incremental transmission costs if they were located there.
In your words, this is your primary recommendation, correct, sir?
I had a number of recommendations. One of my primary ones was to consider BESS in lieu of CT units. I guess
Well, it doesn't say one of my primary recommendations. It says my primary recommendation, correct?
Okay, I can revise this then to say one of my primary recommendations, if that would be better.
No, I want to make sure we agree that this is a recommendation you would like the commission to carefully consider. Fair?
That's fair. I think that one, again, as I reflect on it, I probably is better to restate this as one of my primary recommendations.
Do you know how much BESS the company would need to build at the Oak Creek interconnection site to displace 1,100 megawatts of natural gas fueled combustion turbines?
Well, it would need to be if you're looking to provide equivalent firm capacity, then you would build BESS that provides the same equivalent firm capacity. I mean, the company did this analysis numerous times in their application where CT units were swapped out with batteries that provided the same firm capacity. So that's what I had in mind here. Mm-hmm.
So just to be clear for the record, your testimony is that 1,100 megawatts of BESS could displace the proposed project on an energy and capacity basis?
Well, to be clear, you would need to make sure it would be the amount of firm capacity. So even 1,100 megawatts of CTs would provide a different amount of firm capacity. Same with batteries. We'd have to look at the MISO accreditation of these resources and come up with the equivalent values.
Right. So how many megawatts of BESS at Oak Creek would that be?
I don't have that number off the top of my head, but we could calculate it.
Have you calculated it?
At some point I probably did, but I don't have that number at my fingertips.
Do you know how long it would take to receive regulatory approval for and then build that much BESS?
I don't know.
Have you made any effort to analyze that yourself?
No, I haven't.
Do you think that's something the commission would need to know in order to seriously entertain your recommendation on this point?
I think so, but I also would hope that there would be some ability to leverage the work that's already been done in this proceeding in terms of, identifying the generation need, a site, transmission studies, all that has been, a lot of legwork has been done that could be repurposed, is my belief.
Do you have any idea how much it would cost customers to build that much BESS?
I don't have a exact dollar off the top of my head. We did provide some analysis in my direct testimony about what the cost reduction could be if there was updated battery cost assumptions. And that was based on the company's own analysis of the battery, of the scenarios where they swapped out the batteries for the CTs, but simply adjusting the capital cost of the battery. So I would probably refer back to that analysis to it, which wouldn't necessarily provide the cost of the battery, but it would provide the different costs from the what the company's proposing here.
Okay, so you have, just to be clear, you have not calculated a price tag for your replacement BESS alternative. Is that fair?
I didn't. Right. I mean, not in the same way that the company had sort of presented a total project cost. But that could be done. I mean, it's not a hard thing to estimate necessarily.
As a customer advocate, that would seem to be something CUB ought to know before making this recommendation to the commission.
Well, as I said, we did do the analysis on the difference of the scenario with the battery and with the CT using our updated battery assumptions and found that to be lower in cost. So if you're comparing alternatives, that's why, I recommended that option from, on behalf of CUB.
Let's talk about one more alternative. This time wind. You reviewed the direct testimony of Mr. Arendt and Mr. Hegarty, correct?
Mm-hmm.
Yes?
Yes.
Both Mr. Arendt and Mr. Hegarty testify that renewable resources would need to be overbuilt without long duration dispatchable generation like the proposed project, correct?
That's what they testified, yeah.
And you have not challenged those assertions in your testimony, correct?
No, I think, though, that it would be important to, I mean, no, it's a bit of an oversimplification to say, one resource and others is needed. I mean, this has to be evaluated in the context of a portfolio of generation resources and whether or not that portfolio adds up to the needs of the system. Preferably that would be done through an hourly production costs model simulation, which hasn't been performed, yet by the company or by Mr. Hegarty.
Well, why don't we get into some specifics? Could we please turn to page 4 of Mr. Burgess's rebuttal testimony, Your Honor?
Okay, let me find that.
Thank you.
Okay, there's page 4. Go ahead.
Thank you. At line 7 of page 4, you say, even if wind resources can only provide a partial replacement to the OCCT project, they may still worth be pursuing. For example, approximately 1,050 megawatts of wind may be sufficient to provide firm capacity equivalent to avoid at least one OCCT unit. You see that?
Mm-hmm.
And words, please.
Sorry, yes, I see that.
Now, the way you calculate that 1,050 megawatts of wind is to divide the 220 megawatt assumed capacity of one of the OCCT units by the capacity factor of wind, or 21%, correct?
Right, or yeah, or conversely, the 1,050 megawatts multiplied by 21% is approximately 220.
So approximately 5 times the amount of wind would be necessary to replace just a single OCCT unit, correct?
Well, if you're just talking about nameplate rating, that's true, but these have to be considered in the full context of what they're providing in terms of both energy and capacity and the value to the system. So it's not sort of, I mean, it's a bit of a, I don't know if I would compare them that way as saying that wind is 5 times greater.
Well, that's the capacity equivalency that you established in this section of your testimony, correct?
Yeah, but I guess I don't understand the point of the question here. Is it that I'm not, this is not to suggest that the wind would be sited at Oak Creek. That's not what I was suggesting.
No, we agree. At this point, we're just talking about math. So if we substitute 220 megawatts for one OCCT unit, this sentence says 1,050 megawatts of wind would provide the capacity equivalent of 240 megawatts of combustion turbine, correct?
Right.
And so my question is, approximately 5 times the amount of wind would be necessary to replace just a single one of these 5 units, correct?
If all you were considering is the accredited capacity, then yeah, I think but the general point is that some amount of capacity at OCCT, could be, some of that need could also be met by wind resources, and it may not be that the wind displaces the entire OCCT project, but there's a combination of resources that includes wind, could include batteries, other things that could meet the need, and it could include, some CT units less than 5. I mean, the general point is that wind is able to provide some of the same capacity that the OCCT project is trying to solve for. Now, yeah, you have to have a higher nameplate rating of wind to provide this equivalent capacity, but that's not, that's no reason to, that wind shouldn't be considered as part of the mix.
Fair. And I just want to focus on this partial replacement that you propose as something worth pursuing. Okay. 1,050 megawatts of wind instead of one OCCT unit. Did you do anything to quantify the cost of 1,050 megawatts of wind?
No, I didn't. But I would also add that, that as we talked about earlier, wind was one of the economically selected resources in the modeling. So I think based on that, wind would be a costed resource to include in the portfolio. And certainly, sort of on this level.
wind resources cost approximately $3,200 per kilowatt. Would you agree with that?
I'm not sure if I would agree with that without checking.
Does a different per kilowatt number come to mind for you?
I would
Happy to
refer.
use yours.
Yeah, I mean, I would refer back to, the source I would recommend referring to, for this type of information would be the NREL ATB database that has, I think, good information on cost of wind resources.
Have you reviewed Mr. Gerlikowski's summary of current projects?
Current wind projects?
For wind project, yeah, I believe in his rebuttal testimony, there are 2 wind projects referenced at 3,200 kilowatts and $3,200 per kilowatt. I'm wondering if you're familiar with that testimony.
I don't recall it off the top of my head, but I don't know if there's a reference I can check. That would be helpful.
Sure. Why don't we, yeah, I think why don't we, if you'll work with me at 3,200, your council can always come back and redirect if that number isn't right, but stay with me for a moment on this, will you? I'm just curious, each 220 megawatt combustion turbine unit costs approximately $240 million, correct?
Subject to check. That sounds like it could be right.
And so for each kilowatt of capacity, this Oak Creek combustion turbine project costs $1,090, correct? 240 million divided by 220 megawatts.
Okay.
Any reason to disagree with that math?
No, I just in terms of the nameplate dollars per kilowatt, that seems right.
Okay. And so that's $1,090 per kilowatt for the OCCT project. And we said before that wind resources, at least in recent projects for Wisconsin Electric, cost approximately $3,200 per kilowatt, right?
Yeah, but it wouldn't be appropriate to just directly compare those numbers. You'd have to consider not only well, in this case, nameplate capacity, but also what they're providing to the system in terms of the energy value as well. Wind has no variable costs, well, the CTs do, so that has to be factored in.
Just off the record for a sec, Attorney Goldschmidt, could you just refer me to what the wind projects were
Yeah, happy to go there. We'll have
we don't have to look back at the
well.
testimony, but if you just let me know which projects those were.
Yeah, and we need to be careful about confidentiality here too. So if you'll just give us a moment off the record, we can get you that.
Okay.
Judge, is there a way I can talk to you privately for 1 moment?
Oh, that's well, do you have my cell number?
I do.
You do?
I do.
Okay, well, why don't you try that?
All right, Your Honor, we've got the references for you. Still off the record, we're referring to Badger Hollow wind and Whitetail wind, both in docket 5BS 282.
James, while we were off the record, the hearing examiner was talking to the court reporter.
Okay. Well, for everybody else's benefit then. Hi, Your Honor, we have those project references for you. When you're ready.
You're not hearing me. Okay. Yeah, I guess we can just do that off the record for now. I was just curious.
Yeah, it's so it's Badger Hollow wind and Whitetail wind. Those are in docket 5BS 282. The bottom line, dollars per kilowatt are public in that docket.
Mm-hmm.
They are part of a confidential chart that is on page 25 of Mr. Gerlikowski's rebuttal testimony in this docket. And within that confidential chart, the bottom line dollars are it's 31.87 for Badger Hollow wind and 32.92 for Whitetail wind. So I'm just using 3,200 as a rough number.
Okay, so those are okay. So we are still live streaming, just so you know.
Yeah, that's okay. Those bottom
okay.
line numbers. Those bottom line numbers.
Bottom line number. Okay, that's fine. All right. So yeah, I'm just curious. How much longer do you think we'll have on cross?
Very little. I'm nearly done.
Okay. All right. So let's get back on the record then, and I don't know where we actually left off at this point, but we can. I don't know if there's no pending question. I think it was just my question. So let's go ahead with the next question.
If it's all right, Your Honor, could we have the last question and answer read back?
Sure. Go ahead.
Question, and so that's $1,090 per kilowatt for the OCCT project, and everybody keeps saying that differently. So the last thing I have somebody saying is OCCT. So for the OCCT project, and we said before that wind resources, at least in recent projects for Wisconsin Electric, costs approximately $3,200 per kilowatt, right? Answer, yeah, but it wouldn't be appropriate to just directly compare those numbers. You'd have to consider not only well, in this case, nameplate capacity, but also what they're providing to the system in terms of the energy value as well. Wind has no variable cost, while the OCT lends.
Okay. And maybe where I'll pick up is just to say, Mr. Burgess here, I'm just interested in comparing overnight capital costs of the proposed project and the alternative referenced at page 4 of your rebuttal testimony. You would agree that based on the information you reviewed, we're talking about $1,090 per kilowatt for the proposed project and approximately $3,200 per kilowatt for this proposed wind alternative. Fair?
Right. I mean, based on what I understand, the company is saying the cost of a specific project or two in Wisconsin are for wind, and what the company is saying the cost of CTR. Those numbers seem, consistent with what the company has represented. Again, as I said, I don't think you can sort of like compare those as like direct, like alternatives or, compare the costs in a meaningful way unless you consider the whole portfolio.
Well, again, you're the one who refers to this as a potential partial replacement for the project that may still be worth pursuing, correct?
Yes, as part of a larger portfolio of resources, yeah.
Okay, but even this one partial replacement for one of the proposed combustion turbines would cost approximately 3 times as much, correct?
Well, if you look at the life of the project and what it's providing in terms of both energy and capacity, I think you'd have to then look at what the net present value is of these different options. Again, it's not as simple as just looking at those two numbers and saying one is, cheaper than the other.
Well, I agree. The combustion turbine would also be more reliable and more dispatchable than wind, correct?
And costs fuel.
Okay. So, are you aware of any wind farm in Wisconsin that is over 1,000 megawatts?
Over 1,000 megawatts? I guess, are you suggesting that this has to be one project? Because I wasn't suggesting that.
Do you know how many acres of land that much wind capacity would require, regardless of whether it's contiguous?
Not off the top of my head.
All right, and at 3 times the cost, do you think the avoided fuel costs of wind outweigh that capital cost differential?
Again, I just, the premise of this question oversimplifies the problem here. There's so many other factors that would need to be considered when you're looking at resource options, both the capital costs, the variable costs we've talked about, risk factors, including, future potential environmental regulations. I think there's just a whole bunch of things that need to be considered. And so all my testimony here was meant to illustrate was that wind can be at least part of a solution for providing some capacity to the system that is what, mainly Oak Creek is being proposed for.
And just to be clear, when I refer to 3 times the cost, I'm referring to on a per kilowatt basis. When we talk about the actual total partial replacement here of one $240 million combustion turbine unit, we're actually talking about a $3.4 billion wind farm, aren't we?
If you use those cost numbers the company assumes, but you would have to, again, evaluate this on a sort of long-term net present value basis. Also, I don't know that those projects you cited are necessarily representative of what's available to the company if you look across the entire, sort of MISO footprint. So I would be very careful to conclude that, there's some $3 billion project that would be essentially replacing this one unit. That's not, I think, an appropriate comparison to make.
If you're given whatever assumptions you prefer and whatever values you prioritize in the analysis, do you think there's any world in which a $3.4 billion wind farm is worth pursuing instead of a $240 million CT?
I guess, again, I just disagree with the premise that this is it's like a binary choice in that regard.
I know. So this witness doesn't have legal representation, but I'm gonna tell him not to answer that just based on vagueness, and I just don't think we're gonna get useful information from that. So
That's fine, Your Honor. I'm
Yeah.
done with this line. So,
Okay.
thank
So
you.
I did want to mention just, I think the wind farms you were referencing, I think the commission can find the numbers that you were talking about, and correct me if I'm wrong, it's rebuttal, WEPCO, Gerlikowski, page 25. Just in case they want to check on that. Yeah, is there any more cross from the applicant?
Yes, just to wrap up, Your Honor. On behalf of CUB, Mr. Burgess, what's your ultimate position on whether the commission should grant or deny the application in this docket?
And this is not covered in testimony?
There are a number, from my perspective, Your Honor, there are a number of recommended alternatives, but I'm just looking for a bottom line. This application is before the commission. The commission will have to decide to grant or deny it.
That's fair. Okay.
Which is it from this witness?
Yeah, I would want to defer to CUB on this point, but my general recommendation here is that the application, I guess, setting aside, any legal requirements, I think this application should be at least delayed until more information is available, particularly around the large customer, the very large customer tariff, and more information, I think, about alternatives. And so, again, I have some sense that there's some timing or legal requirement about that, which suggests, perhaps a denial. But, again, I think that preferably it would be delayed and reconsidered when that additional information becomes available.
So is it a fair summary of your testimony to say that if the commission cannot delay the application, then it should be denied?
I guess that's a fair assessment. And again, I would defer to CUB on that.
Yeah, you're not speaking on behalf of CUB on that point. You're speaking on behalf of your own expertise.
Yes.
Yeah. Yes. Is that a yes? Can you answer, witness Burgess, whether you're speaking on behalf of CUB or your own, on your own behalf, I suppose?
Yeah. I think it should be. What I don't fully understand is whether or not there's any leeway to accept the parts of the proposal or not. I think that one thing I did put forward as a potentially good option would be to consider just 2 units of the Oak Creek proposal. I think that would kind of strike the right balance here. But if that's not possible, I think that denying now and perhaps coming back at a later date would be the preferred route.
But before I ask my last question, Your Honor, did that give you an answer to your question?
It's okay. We can move on.
Okay. Mr. Burgess, as a witness for the Citizens Utility Board, does it make any difference to you that the significant economic growth driving the need for this project has been a major initiative of policymakers, including Governor Evers and members of the Wisconsin legislature?
I think that's an important consideration, and I don't, none of what I'm recommending here is intended to in any way restrict that. You know, I think that there's the basis for my thinking here is that, you know, it's not clear to me that this specific project is needed to meet those economic development objectives. And so I think to the extent that, you know, there's other ways that the economic development could be served that haven't been fully considered or explored, I think that would be what, you know, we should aim for here. And so again, this is, as I mentioned earlier, there wasn't much, if any, initial analysis that went into, you know, sort of identification of these projects on the front end. And so I think it's worth considering, you know, can we still achieve those economic development goals while looking at options that provide adequate protections for existing customers and meet other societal goals rather than sort of rushing it into this specific project.
Okay, thank you. So we're gonna go into a break, but I wanted to ask if there's any other cross for this witness, other parties, commission staff.
Your Honor, I do have some brief redirect.
Okay.
We can take a break if needed.
Yeah, I think we're
that.
still going to take a break. Just put a pin in that. And hopefully we can get back. So let's take a break for 15 minutes and then we'll check in and see, maybe we can at least get that redirect done. Then I'm actually contemplating breaking for the day. So just give you a warning there. Okay, so but for now, we'll be back at 3:45. Thanks. Hmm. Okay. So let's see, we're getting our people back here. There she is. Okay, great. All right, so I think we have everyone we need. See the witness there. So let's get on the record and have redirect from Cub.
Thank you, Your Honor. Good afternoon, Mr. Burgess again.
Good afternoon.
So I just want to revisit a part of the conversation you had with Attorney Goldschmidt. He asked you about your experience in as it relates to resource planning. Do you recall those questions?
Yes.
Yeah, and I believe it's in your direct, but just in brief, you have experience doing capacity expansion modeling and resource planning modeling in other states, correct?
That's correct. Yeah, I've done a number of studies and analyses using capacity expansion models to represent specific utility systems using data sets from those utilities as well as others from publicly available sources, and done that as part of both formal and informal resource planning proceedings.
In your experience with that type of resource planning work, would it be fair to say that the generation resources are typically evaluated against a number of different alternatives in terms of resource type?
That's right. Yeah, usually there's a portfolio of resources there's an existing portfolio of resources, and then there's a variety of candidate resources that can be added to the portfolio over time, and the modeling attempts to optimize for the least cost generation portfolio by selecting from a number of candidate resources, and usually there's a variety that are added. And it's not sort of a one-to-one sort of comparison in those situations.
Okay. And in that experience, is it typical that energy efficiency and demand response will be included amongst candidate resources?
Not always. What I think has historically been true is many utilities include energy efficiency as a sort of modification to the load projection. So it's not considered as sort of a selectable resource. But what some utilities have begun to do, and what I think is an appropriate method would be to allow the models to select those resources as candidates. Often what we see when that happens is that the model will select the maximum available amount of cost-effective energy efficiency.
Let the echo die there. And also in that planning, would it be fair to say that the load forecast that those resources need to meet is typically an issue in that evaluation, in that analysis?
Are you saying that or data?
That, sorry.
Thank you.
Sorry, just to clarify, were you asking that whether the load forecast is an important assumption in that modeling?
Yeah, that would be another way to put it, is when developing a portfolio as a part of a resource expansion plan or an integrated resource plan, is the load forecast, an important input to that analysis?
Yes, it's one of the most important inputs. Usually it's the starting point of the analysis in developing that load forecast going forward. And Yeah, so I'd agree.
And again, in your experience in these other states, is the strength of the inputs used to develop that load forecast something that is commonly evaluated and reviewed?
Yes, it is usually reviewed, and there are different methodologies for performing a load forecast that are evaluated in those situations.
And part of that evaluation, would you agree, is trying to determine what the evidence says about the likelihood that the future forecast that the future load of the utility will sort of unfold in the way that is baked into is input into the model. Would you agree with
Objection
that?
leading, Your Honor.
I'll allow it. You can answer.
Right. So the question being, sorry, actually, could you repeat it? I got a little off track there.
Could we have it read back, please?
Go ahead, read it back, unless you want to. Well, okay.
Question, and part of that evaluation, would you agree, is, trying to determine what the evidence says about the likelihood that the future forecast that had the future load ever. I'm sorry. Yeah.
Okay.
The utility will unfold in the way that is input into the model.
Yeah. Right. So yeah, trying to determine, what's the likelihood of that forecast. Yeah, that's very key. I think often there are multiple load forecasts evaluated, sort of a range of potential load forecasts, and some sort of assessment of the the likelihoods of those different futures, which can be and yeah, I guess I'll just leave it at that.
Yeah. And so is it your testimony that, well, actually, sorry, strike that. Do you recall the questions Attorney Goldschmidt asked you related to service agreements and tariffs, and your testimony regarding the fact that there aren't any at this point? Do you recall those questions?
Yes. Mm-hmm.
Okay. Just so it's clear on the record, is it your testimony that the fact that there is not to date tariffs or service agreements related to the large new load additions in the load forecast tied to your position with respect to the likelihood of that load forecast?
Yeah, I think there's some linkage there. I think certainly I have a lot more confidence in the load forecast if there were underlying service agreements. In fact, it brings to mind the approach that's taken in by Dominion in Virginia, where they develop a load forecast for large loads and then take another step to validate that forecast based on existing energy service agreements, as well as there's different sort of tiers that they have for potential service agreements that may be in the works but aren't fully baked yet. So I think that's one approach I think that could be considered.
Okay. Attorney Goldschmidt asked you some questions about energy efficiency and the amount of energy efficiency that could be, I believe his words were, depended upon at various points in the future. Do you recall those questions?
Yeah.
Okay. And I believe that you had testified in response to one of his questions that the amount of energy efficiency that one could assume or one could count for the future, one could assume in future years is a function of the budget that those energy efficiency programs have, and that budget could be scaled up or down depending on what your assumptions are about those programs. Is that an accurate capture of your testimony?
Yeah, I would say, there's a few factors that play into, how much energy efficiency can be achieved. Well, one of the most important ones is the amount of funding or the budget that's applied towards that those programs.
Okay. And he asked you some questions about the budget as it relates to the Focus on Energy program, and you're willing to accept, you believe you agreed with him that the current budget for the Focus on Energy program for Wisconsin is set by Wisconsin statute and so is fixed at this point. Is that correct?
That's what he represented to me. Yeah.
Okay. And a few minutes ago, you had just mentioned that from your perspective, in terms of modeling resources, resource plans, and candidate resources to meet a future load, that you believe that a good practice would be to allow the resource optimization model to select energy efficiency as a resource similar to generation resources. Is that correct?
Yeah, that's correct.
Okay. So given your testimony regarding the function of the performance of energy efficiency and the amount of energy efficiency that one could predict in the future, and your position with respect to how energy efficiency should be modeled in the testimony, modeled in the resource plan, would it be fair to say that your position, the way that you believe energy efficiency should be modeled is not the way that you understand it's being modeled in WEPCO's Plexos modeling?
Objection, leading. Would it be fair to say is classic leading, Your Honor?
Is it your understanding that, sorry, strike that. Has WEPCO performed its resource modeling in this proceeding in a way that incorporates energy efficiency consistent with what you believe is a better practice?
Yes and no. They did allow the Plexus model to select, economically select energy efficiency and demand response resources. However, they limited that amount to a degree that I did not agree with. The limitation in each year was, we kind of discussed this earlier, but it was, subject to an arbitrary 50%, reduction from one of the focus on energy potential study scenarios. So my recommendation would be, to continue to allow the model to select energy efficiency and demand response resources in the way the company has, but to increase the limit on that to reflect all cost-effective energy efficiency that could be achieved rather than the small and somewhat arbitrary limit that the company selected.
Given that the Focus on Energy program budget is currently fixed in statute, increasing that amount of energy efficient, would increasing that amount of energy efficiency in the future require additional investment from the utility?
Well, you could certainly model it without that statutory limit and see what the results show. My expectation was that the model would select a lot more energy efficiency. So I think the question is, what is the reason for that statutory limit if it's preventing cost-effective energy efficiency from being achieved?
Okay. But if Wisconsin utilities are allowed to make investments in voluntary utility programs. Would that be, from your perspective, an avenue for that additional investment?
Yeah, I would encourage, those other options to be explored. And I think that might be a different, another way to achieve the same outcome.
Okay. A couple more questions. Attorney Goldschmidt asked you some questions related to renewable or variable resources, and I believe Mr. Gerlikowski's testimony, where he stated that those types of resources, in particular wind, would need to be, quote, overbuilt to meet capacity needs. Do you recall that?
Mm-hmm. Yes, I do.
Okay. And I believe the two of you went through a little bit of a math exercise where you, at one point, discussed the application of the capacity factor for wind to the hypothetical amount of displaced Oak Creek CT capacity. Do you recall that?
Yeah, and just to clarify, it was the capacity accreditation, not the capacity factor, but yeah.
Thank you. Thank you for that clarification.
Mm-hmm.
Okay. Is that, in your experience, well, maybe backing up, strike that. What was your understanding, or what is your understanding of how Mr. Gerlikowski used the term overbuilt?
I think he was talking about the fact that the wind has a higher nameplate rating than the CT unit to provide the same capacity value. But as I discussed, I don't think that's a meaningful comparison to make. Ultimately, our concern is about whether the system can be operated reliably at least cost, and so I think that focusing on both, whether or not you have a system that meets resource adequacy needs and that also does so at a low cost, both in terms of not only the nameplate capacity, capital costs, but also the ongoing operating costs and potential risks involved with different options.
And so that overbuilt is the amount of nameplate for something like wind relative to the amount of nameplate for something like a CT. Am I understanding that correctly?
Right. Yeah,
Okay.
just on that simple nameplate definition, that's what I think was being compared, yeah.
Okay. Would that same differential that would produce an overbuilt situation apply generally to any wind resource?
Well, at a high level, yes, but wind resources can also vary in terms of their output. So you may find that some wind resources you have to build or quote overbuild less than others. But yeah.
So just to be clear, in general terms, yes, that there can be facility level differences, but thinking about wind resources generally, that would be true.
Right.
Okay. And so would it be your expectation that that would apply also to the Badger Hollow Wind and Whitetail Wind projects that Mr. Goldschmidt referenced, that We Energies has applied to acquire?
Yes.
All right. I have no additional questions. Thank you.
Okay. Excuse me. All right. Thanks very much. You're excused. You're excused.
Thank you.
All right. So let's take a break here. We can go off the record. I think we're going to break early today and continue on with tomorrow for the remainder of the witnesses. Maybe we can get them in all tomorrow, but we'll see. We do have Friday as a spillover day cleared on the schedule.
looking at the witness list here, I think there may just be one constraint with Jester for tomorrow, but everyone else I think is available. I'm not, just correct me if I'm wrong, if I need to know something about witness availability for who's left.
Judge Newmark, Dr. Nunez for HW UCS is only available tomorrow from 12 to 4. So we were going to propose to possibly do this today to not have to fit within that window. I spoke to Clean Wisconsin and they were okay with it, but also understand if you want to break for the day.
Yeah, I can't, we were not going to be able to do that, but so let me just, so only available between 12 and 4 tomorrow. That should be plenty of time, a big enough window to get the witness in without a problem. So hopefully that'll work. Anyone else with time constraints?
Yes, Your Honor. For Andrew Kell's testimony for renew, he can't affirm his testimony on Friday morning. So if possible, if we could do that tomorrow.
Okay,
if we were to extend into Friday, I mean.
Okay, did that witness need to add any testimony? Was that the intention?
No, he just wanted to affirm on the stand. But...
Okay, because we can accept Kell with an affidavit. He wouldn't have to appear at all.
Okay, I mean, I'll check in and.
Okay, but potentially, yeah, tomorrow would be the day for Kell. That's what you're saying, essentially.
Your Honor, I'm assuming we'd reconvene at 10 a.m. That's what I checked with my witnesses.
Yes, I actually was going to propose a 9 a.m. Start time, if that's okay with everyone.
Applicant supports that, Your Honor. We could start as soon as 8.
I'd have to consult my dog. Otherwise, okay. So if 9 o'clock's okay, we can start then, and just catch up with that extra hour. I wasn't expecting to go much later than 5 at this point. So, all right. Anything else?
Your Honor, I had a court hearing at 8:30, and I hadn't moved it because I believed we were going to do 10 a.m.
Okay.
I don't have any witnesses or intended cross as of right now. I can probably be in and out pretty quickly, so I don't. If it's all right with Your Honor to be excused for some portion of that 9 a.m., I will return to my computer screen as soon as possible.
Yes, that's fine. Thanks for giving me the notice of that. And yeah, that's not a problem. Sorry for cross scheduling here at this point. But I don't think there'll be much harm in this situation. And I think we'll start with Cub again. So start up with Cub. So hopefully you didn't have any, depending on, well, you may have an interest in that, but yeah, and then there will be of course, the video and the transcript to refer to if you don't have any questions. That you probably do. Anyone else? All right, so we'll adjourn until 9 a.m. tomorrow. Same connection. Thanks.
Thank you, Your Honor.